Welcome everyone to this Monday, May 10th edition of Money Banking and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology. This is the Monday meeting for the Trust Ambassadors, so welcome all Trust Ambassadors there. I'm going to, what I talked about on Saturday here, I'll go over a few sections. I'm in the Banks and Banking section of Corpus Juris Secundum, Book 9. And this is the 1996 edition. I'm going over section 204, which is trust funds in general. And it says that whenever a bank is an agent or trustee, the principal beneficiary has a preferred claim for the return of the subject of the agency or the trust. So as a general proposition, whenever the bank holds property or the proceeds thereof as agent or trustee, rather than as debtor, the trust fund, if intact, is entitled to preferential payment or priority, and the general creditors have no equity requiring the application of such funds ratably to the satisfaction of their claim, since a claim for trust funds is based on title to specific property, not properly a part of the assets of a bank, and is in no sense a claim against general assets of a bank held in trust for creditors. Nevertheless, trust may be denied priority in the absence of a written acknowledgement of the trust signed by the bank as required by statute. It has also been held that a deposit with intent to create a trust will not be accorded priority if it was also intended that the funds be mingled with the general assets of the bank, since the right to use property is inconsistent with a trust. Some authorities hold that the term preference is not properly applicable to a claim for the return of trust property sufficiently traced or identified. There seems to be no fixed rule determining what constitutes a trust, which is to be treated as a preferred claim, and each case must be decided on its own particular facts. However, the rules applicable to trust generally will determine whether a trust exists, such as is entitled to priority on insolvency, and so a claim will not be enforced as an express trust unless there are sufficient words to create a trust under the general rules. And every trust, express, implied, constructive, or otherwise, requires an ascertainable object or fund. The trust requires a fiduciary relationship. The trust requires a fiduciary relationship. A claimant will not be required to elect between a general claim and an equity proceeding to recover trust funds, but may pursue the trust as far as can be traced and then file a claim for the balance. And the next section is 205, tracing funds, and I'm going to Section 206, effect of intermingling or conversion. Although there is an authority to the contrary, conversion of trust res or the intermingling of trust funds with the bank's general funds will not destroy but the same will be impressed on the funds coming into the hands of the receiver or upon property obtained by or substituted for the converted funds. It has been held that the mingling of trust funds with the general funds of the bank does not extinguish the trust or defeat the right of the beneficiary or follow the recovery of trust funds or its equivalent, but such general funds are impressed with a trust to the amount of the trust fund which has been commingled with them. According to some authorities, this right of priority of claim extends to all the assets of the bank, and a similar right may be accorded by statute. However, there are some authorities hold where the trust funds have been mingled with the bank with its general funds, or where it is made impossible to identify or distinguish the funds from other deposits, the beneficiary can no longer claim priority in such funds. It has also been held that where a bank wrongfully mixes a trust fund indiscriminately with the other funds from which operations of the bank are conducted for an appreciable period of time, it cannot be said at the end of such transactions that the trust money or any part of it is in the possession of the bank. Next section, existence and continuance of general funds. According to the authorities who hold that a claim for an intermingled trust fund is awarded priority only as a cash which comes into the possession of the receiver at the time of the closing of the bank, and not as a bank general assets, it is necessary that there shall be remained in the general funds of the bank from time to time at which the trust fund is mingled, till the time such funds come into the hands of the receiver, an amount of the money equal to the amount of the trust claim or of the amount to be awarded priority. But where the continuance of such an amount in the general funds of the bank is established, the claim will, as a general rule, be awarded preference, and it will be presumed in the absence of a contrary showing by the receiver that the trust funds is included in the money coming into the receiver's hands, although according to some authorities, the trust property must be traced into a specific fund coming into the hands of the receiver, notwithstanding the cash balance is continuously adequate to satisfy the claim. According to the authorities holding that the trust fund is awarded a preference in which all the general assets of the bank, it is not material as to which the cash assets after the money came into its possession were at times thereafter less than the amount of the trust fund. Let's skip this rest of the section here and let's go on to maybe a little section here, 207, augmentation of the assets. It says in the first sentence there, where no specific res can be identified as the original trust fund because of the conversion or intermingling of the original fund, the claim is, in the absence of statutory provision to the contrary, entitled to priority only where the assets of the bank coming into the hands of the receiver have been augmented by the disposition of the original trust fund. A deposit of cash or check or draft on another bank augments the assets of the bank deposit. And we'll skip the rest of that. Next section, 208, special or segregated deposits. Special and segregated deposits are ordinarily entitled to the same priority as other trust funds. Research note here says special deposits are discussed generally in INFRA section 283 through 286, and we went over that on Saturday in depth. Where the circumstances of a deposit are such as to make it a special or segregated deposit and render the money or thing deposited a trust fund, it is ordinarily entitled to priority in accordance with and subject to the rules stated supra in sections 204 through 207 as to trust funds generally, which we just went over. For an alleged special or segregated deposit to be entitled to priority, the circumstances or agreement under which it is made must be sufficient to render it a special or a segregated deposit in fact. What was originally a special or segregated deposit may be denied priority if the depositor has permitted it to be converted into a general deposit. Don't ever let you, as being the depositor, your special deposit, be permitted to convert it into a general deposit, or claim priority to the insolvency of the bank, or has waived the right to priority. You will waive the right to the priority. If, however, a special or segregated deposit was in fact intended and created, the manner in which it is formally evidenced or entered on the books or records of a bank is immaterial. The manner in which it is formally evidenced or entered on the books or records of the bank is immaterial, and the acts and conduct of the bank in treating the deposit as a general one cannot of themselves deprive the special depositor of the right to priority. I'll read it again. The acts and conduct of the bank or the court or any other agency, the acts and conduct of the bank in treating the deposit as a general one cannot of themselves deprive the special depositor of the right to priority, unless the depositor has consented thereto or acquiesced therein. So with that sets the pace. Let's open it up for talk, Q&A. Press *6, state your name, where you're from, let's talk about what we just talked about now, and let's go over what we talked about on Saturday. And the Saturday show was NTT and the nature of deposits. So let's limit your questions to that and that alone for tonight. Anybody have a question? Press *6.
Yeah. This is Floyd.
Hey, Floyd.
Yeah, so whatever you say then, as far as your deposit, if you say that's a special deposit, then that's a special deposit, and the courts can't argue that, nor can the banks argue that.
That's what it's saying. It says if you intended it and you created, and how would you create it? You'd have to have necessary and a method of formation, and then have the record to prove it. And if you had the record to prove that it was created and it was your intent, then the formal evidence entered on the books of records of the bank is immaterial, even though they stick it in the general fund.
Yeah. Well, see, this is what I was saying the other day to somebody. I was talking to somebody about this, accepting the bank card and all that, and I said I don't think that's really the place that's all that important, because
the form is not controlling.
Right. Once you got a bank account, if you go back and correct that mistake, and you put it into the public, and you accept your account, or well,
yes,
like
you as the depositor are being duped and coerced, and for you to waive your right because the depositor has permitted it to be converted into a general deposit, quote unquote.
Yeah, and they knew what they were doing, even if you didn't. But
that was
remember,
the problem. You didn't know what your rights were, and then therefore you had no rights.
Yeah, and so but now that you know you have rights, you can go back and you can correct your mistake, and what you do now will supersede what you did in the beginning.
Right, that's correct.
Yeah. So you can accept your bank statement then as trust, as res.
Yes, if you have the intent and that you created the evidence that it was a trust, yes.
Well, put it in the public, accept it and put it in the public. And then say,
unmuted.
Go through the steps of proving trust.
Yeah, we're the ones that are supposed to be creating the records. I talked about it on the show Saturday that we have no set of trust.
Christian, I have a question.
Yeah. Hang on a minute. Let me mute.
Muted. Unmuted. Muted.
Okay, caller. Press *6 again to unmute yourself.
Unmuted.
Hey, Christian, it's Terry.
Hey.
So what you're saying, technically, everything we've ever deposited into a bank account, if we come back at a later time, express it as a trust, we ought to be able to order the bank to return it exactly in the form that it was deposited, be it a payroll check or cash or what have you. Is that correct?
I would say so. Anything you put your signature to is being deemed as general deposit and not a special deposit. And if you got the evidence to create it or correct it, then I don't care how far back it goes.
And does it matter that we wrote checks on that account to utilize those funds in a different manner rather than letting them sit there and demand them back later?
Well, I didn't come into this knowledge until just recently, they say, and then I realized it was not my intent, and it was a mistake, and therefore I have the right to correct it. And here's the evidence to say that this was, from the beginning, nunc-pro-tunc, a...
So the bank would, for lack of a better term, be on the hook for everything it processed by way of our checks?
All proceeds therefrom, generated from the signature.
Okay, restate that, please.
Yeah, and along with all the proceeds therefrom generated off your signature.
Okay, but what I'm getting at is if, say, you made a deposit and you wrote a check off of that account to make a mortgage payment, then
Yes.
if you go,
Go ahead.
if you go now and say, okay, I want every special deposit I ever made it into this account, then what occurs with all those mortgage payments?
I don't know what incurred with them, what they used the funds for. I have no idea. You know.
That would be their problem.
Right. As long as it's traceable back into where you can trace it to get, to where they've received it.
So as Floyd alluded to, we should be able to take our bank account statements and reclaim everything that was ever placed into the account.
Yeah, I think so.
Interesting. Just by expressing it as a trust.
It comes back down to like Saturday's show when I went over, the City Key Trust. Everybody's talking about the Foreign Situs Trust, City Key Trust, the birth certificates, the Social Security. They're all trust. No, they're not trust. They never were trust. Just like your general deposit of your checking account and stuff, they're not trust either.
Until we express it.
Not until you express them to be trust do they become trust. And you're the only one who can. And you never did. I never did. You never did. Nobody ever did. Nobody has done it yet, I don't think.
So taking it to the City Key Trust, once we express it, it just exists from that time on.
Yes. From the time that they had trust res.
Okay.
In the hands of the trust.
So it's really there in the background until we express it.
Yep. That we're creating the whole thing ourselves, that we're going down the wrong path. We're going down the debtor-creditor path, which is the general deposit, instead of going down the trust path, which is special deposit. And we're the ones creating it. We've created all this mess ourselves.
We're the
only ones who can correct it.
So what you're saying, go ahead, CW, I don't want to interrupt you.
We correct it by just doing a withdrawal of the funds out of debtor-creditor or general deposit and redepositing them in by special deposit into trust. It's that simple. Withdrawal and redeposit. That's the same as merging titles. That's the simplicity of it all. That's what's been hiding it all along. It's been so simple. Couldn't see it.
Well, the thing is, we don't know what the amount we're withdrawing.
I'm withdrawing all the debt and merging it into the other asset side of the titles. And when I merge it, then that's going to extinguish the debt. Now, I can be specific and say I want one particular case, say, a debt title, and merge that in there and take care of each individual one. But, why don't they just do it all in one fell swoop?
And then then we turn around and do a special deposit of whatever amount of money or we want to put in back into the account.
Or the remainder in another trust, because everything's going to have to be held in trust and kept private from here on in.
So do we go to Rios or what? And structure?
Probably go to Rios because that seems to be the private side, I would say.
So we instruct Rios, okay, we want you to put this amount of money into this trust. That's it. Once we go to the commissioner of the IRS and withdraw the amount out of it, right?
Yeah, we might not even have to specify Rios if we're just using the IMF to correct or whether it's even the IBF, whatever it is. The master record file, let's put it that way.
Can I say something?
Yeah, just take all those assets out, all those debt assets, and redeposit them on the other side, and that's going to extinguish the debts. Go ahead, Floyd.
Yeah, I think we have to I think we have to remember that when we're dealing with trust res, we're not dealing with a specified amount anyway. We're just dealing with a thing.
We're not dealing with a value. We're dealing with a thing.
Right.
The
And so all
value
we
is
have
really
to do-
it's my interest.
Right. We just have to express the res, and that's it.
Yes.
Yeah, but what? Go ahead, Floyd.
Well, we have a tendency to get figures in our head because we're so used to debtor creditor.
Uh-huh.
But
Well,
once we start to see trust, we're not dealing with dollars anymore. We're dealing with a thing. So we have to start expressing it as a thing. As an example, on my telephone bill that I've been working on, I was putting down an amount that I was depositing. But then after talking to a couple of guys that know more than I do, I began to understand I don't have to do that. All I have to do is just return that. See, what that form does is it's representative of my res. It's not specifying a res, even though it's a specified. It's a specific res, and it's a specific deposit, but it's not specific as far as dollars and cents go.
Value.
Value, yeah.
That value is debtor creditor. It's a dollar amount specified in fiction dollars or whatever.
Right.
It just represents a debt. It's a thing.
Yeah. It's just a representation. That's all it is.
My question is, once we do this, we withdraw it, then we open up another trust account, and then it's at that point in time we got to be able to function in society and be able to pay our bills or whatever the case may be. But that basically we're just writing a check on an open account, and we don't really need to be concerned about money. Is that what you're saying, or a dollar figure, or a set amount?
Right. Might need an LLC connected to that trust to interface back in, and that LLC would kind of be trustee on that trust side.
For that matter, do you need to fill in an amount on any money order or check you write?
Well, I think when you're dealing with the public realm, they want to see a value amount.
So we're
But if
dealing.
we're dealing in, it won't be an amount. It'll be just an interest. So there's a conversion from the dividing line from private to public, and we need an agent to do the conversion, and they're the agents that are supposed to do the conversion, and they have to do it because we're the creators. We're the grantors of the whole thing. They must. They probably will, because when you know what you're doing, when you reach the point that you can do the jump, and you can do the jump by you're giving the order, and you know that they must do it.
So the bottom line is that account is limitless.
Right. As far-fetched as that may seem, yes, because it's limitless in the value of dollars.
It's like your sovereignty is limitless, and you have to think of that in that term. You have to think of your sovereignty as trust res also.
Right.
Do we still claim the Declaration of Independence, or no?
Yeah, I would say I would claim the Declaration of Independence. That would have some kind of standing as to an association with.
Yeah, because the thing is, what I was going to do with my little case that you know about is do the scripture, then the Declaration of Independence, and then fall in there and then give a special deposit and give an order to the sheriff to disperse the funds, and then go from there. Pretty much what we went over on Saturday.
Right, right. I'm proud to be an American, but I'm stupefied to be a United States citizen.
Mm-hmm.
See, you have to have tenure in there somewhere. Right, Christian?
Yeah, the tenure would be the life estate, but hey, We just became sentier.
Would the tenure come once we express the trust?
Say again?
Wouldn't the tenure come once we express the trust?
Well, we could have, you know,
depends on
the
how you
tenure is
express.
something for the public to. It's been there all along. It's just we never say claimed it, or we just didn't come into the knowledge of it.
Right. So we have tenure now. We just haven't expressed it.
Yeah, because what I'm going to do is I'm going to pull all my debt titles out of that debtor-creditor realm, and I'm going to create an estate in private. The estate's already there. I just become aware of it, say.
Well, do we identify the estate with the BC or the Social Security, or we just completely forget about that?
No, that's all part of it.
Yeah, I believe that's part of the debt titles.
That all has to go into trust.
Well, the trust res.
Yeah,
that's part of
we
the
merge
trust.
titles. That disbursement that'll close down the terminate the trust, and then the disbursement will have to be made.
So Christian, if I'm sorry, go ahead.
Be dispersed into that new trust.
So if I'm hearing you right, you're not telling us anything new or different, rather, than you've been saying all along. We just need to realize that those trusts were not in place yet, and don't assume so. We have to make the effort to express them.
Right, and simultaneously you're operating on both sides, because you're going to look at it under debtor-creditor. They want to see a withdrawal and a redeposit. That's debtor-creditor say. But really what you're doing is trust, which is you're merging the two titles. So you really got a knowledge of both sides of what's really happening. Before we didn't have that.
Christian?
With a more clear view of what is actually happening, and when you understand that, now you're in control of it.
Before in debtor-creditor, everybody looks at, when they look at debtor-creditor, they look at all the forms that they have to be filling out and understanding and all that. And all of that's public, and they never think about the private side, and they don't understand the private side. So what they do is they get lost in the public side, and then they go off in the direction of memorizing all of these UCC 301s and 9010s and all of this stuff, and all of that can be put into trust.
A deposit may be the cloak for some other transaction, such as a payment or the giving of security, and in such case, equity, looking through form to substance, will treat the transaction according to its real nature.
There's your trust.
Beautiful.
All of this smoke and mirrors, it just cuts through with equity.
Cloak the smoke and the mirrors. Yeah.
That's exactly what it is.
Christian?
Yes.
What would you do if you did an allonge and you did the settlement and the closure using trust res out of a UCC1 with a UCC3, and it's been over 30 days and you haven't had a response back from the banks? Would you redraft them at this point, and what would you redraft them with?
All right, I had an allonge on a note, and I did
Yeah,
what with it?
I actually used the allonge process and executed the settlement and closure of a mortgage, and it stopped the sale, and I haven't heard a word, and it's been over 1 month since I did that process with them, and I was looking for the closure and the settlement and the disbursement of funds coming back, but still haven't heard a word. Would you touch that with a 10-foot pole, or how would you handle that situation?
Well, I'd demand a statement of accounting, or what you're entitled to under an entitlement.
Okay.
Because you were the creator of the funds.
Did you put a time limit on that?
Tell them I want to do a tracing.
tracing?
Now, I want to trace the funds back. If you're not going to respond, I'm going to deem you breach of trust in, say, 14 days.
Okay, because I think my original allonge was only 3 days that they had to respond once they received it.
Well, if it didn't respond, you gave them 3 days, then certify that there's a dishonor there, and that would give them notice of a breach of trust.
Okay.
And then
So
demand
in other
to
words,
have,
I should just go ahead and dishonor them through like a default for the notary, of which she's the one that served it, and therefore send them a copy of the notification that they're in dishonor and breach of trust.
yes, all right.
Okay.
I think
good.
it's
All right.
3-307 under UCC. Look at that. That's notice of breach of fiduciary duty.
Okay. Thank you.
Yeah, without notice, once you give them notice, now they're that brings in a lot of realm enforcement.
Should I have the notary sign off on that too?
The notary sign off? How do you mean?
Like a notarial protest or an acknowledgement that no response has been
under
back
his
to
hand
her?
that he's given you a certificate of dishonor for the breach of trust.
Okay. Good. Thank you.
To express these trusts, do we have to call it a 7K trust or anything, or can we just publicly notify that trust exists like we talked about before?
If you want to call it something, you can. I mean, if it fits the description of a city key trust or a particular kind of trust, but then it's far more encompassing than, say, the birth certificate or the Social Security. Who knows what else is in there?
The birth certificate trust is it's expressed that it was a trust, and posted.
One small portion of it. We don't know. Neither do I care. Just withdraw all the debt titles out of that general deposit and redeposit it with a special deposit for a specific purpose, which would be any 1776 lawful or purpose, as well as extinguishment of the debt.
Christian.
Hey, Pete. How are you?
I'm good, thanks. How are you?
All right. Doing okay.
Good, good. Cracking call tonight. What I was wondering is, under gift law, then there is an onus on whoever receives the property to pay a tax.
Yeah, a tax back to the beneficiary for the use of the property.
Yeah.
From the trustee under feudal law. Is that what you're talking about?
Yeah, it is. Yeah, is that to be utilised at any point for leverage?
Well, I could say, I'm the trustee on this trust, and I know for a fact that you, so-and-so, are not the beneficiary, so you do not have the right to take. So I don't owe you anything. Only the beneficiary has the right to take. But I know that fiction, that entity is trying to collect is not the beneficiary. Since you want my signature, you want my name, I'll grant you my name, but I'm going to put conditions on it in confidence and reliance on you can have my name to be returned to me sometime in the future along with all the proceeds that were generated from this signature. And I'm going to give it back to you as a special deposit for the payment of the free offer for the obligation that you gave me.
Is JC on the call?
He might not be on till about after. Yeah, he may be coming on about now.
Well, the reason why I asked, didn't mean to interrupt you, is that we can start getting together and getting these documents and then go over them in the group and then go from there. Brainstorm on them.
What he should do is go to the law library and hit the corpus juris secundum section and copy the sections that I went over.
Okay.
And read them for yourself. And there's probably more that we need to know, maybe specific wordings and getting our vocabulary down so that we can build some pretty good indentures, or at least we can simplify it, the indentures, but yet we can keep the complexity of the definitions and things in reality of what's going on in our minds. And that'll be the true understanding of having the knowledge. In that way, I can dodge the bullets. I can move with speed that nobody can comprehend because I can read and write the code, and I'm in control of my own destiny.
Guys, JC's just asked me to drop the message that he is on, but he can't unmute.
I can't unmute.
Excuses, excuses.
He's saying, ask about claiming the BC, simply a signature on the front, or endorse per instructions.
Yeah, if you just wanted to do the BC bond, yeah. I'll just sign the front and turn it over in the back and then do the endorsement on the back instead of the pay to in blank. I think I'd change the pay to line to by special deposit.
Well, thing is, you know, when I was arrested and I told them, you know, by special deposit, their eyes lit up. I hit a nerve. So this is dead on, CW.
Then the other thing I wanted to ask on, I looked at Uberima Fides, where it goes into fiduciary duties. And it's the fact that a contract is one of utmost good faith does not, however, mean it gives rise to a general fiduciary relationship. The relationship between insured and insurer is not akin to the relationship, say, guardian and ward, principal and agent, or trustee and beneficiary. In these latter instances, the inherent character of the relationship is such that the law has traditionally imported general fiduciary obligations. The insurer-insured relationship is contractual. The parties are party to an arm's length agreement.
I'd pay attention to when they say general.
Yes.
Is it general circumstances versus special circumstances or specific circumstances?
So you've talked on a couple of past shows where you've said about underwriting things. How does that tie in with trusts?
Well, the fact that I got a trust, that is a bond, that is my underwriting.
Oh, nice.
Now you say you signed the front of it. How so? If you're going to sign the back, both sides?
Yeah, I'm going to put my name across a 45-degree angle, and I'm going to put a date on there, and I'm going to see reverse side.
On the front or the reverse? I'm a little confused about what. on the front, you put a date and you print your name in?
No. I'm going to sign my name across the front. I'm going to put a date on it. I'm going to see the reverse side.
Okay, and on the back side, then you'll have you'll call it a special deposit.
Yeah,
And
without
then sign it.
recourse for special deposit and leave it blank. And then another signature line for my endorsement as, say, trustee. And then the next line, the all caps name, trust account, social security number without the dashes.
Even on a BC, it has social security number?
Yeah, even on a birth certificate, yeah. Because on the
Okay.
reverse side, I'm stating the account which is to be drawn against, so to speak, if I want to look at it that way.
Okay.
And I was going over some stuff today that I found out that if I can pull it up here. It was under the bills and notes, I believe. Or was it? No, it might have been beneficiaries. I don't know. Maybe I won't go into it anyway. I don't have it pulled out.
Christian?
Yeah, Chris, go ahead.
Guess what I found today in a promissory note? I haven't heard us talk about this, but I wanted to share it because I think it's important. It said the trustee/settler at times with capacity of beneficiary. Now, isn't that kind of some of the language we're looking for to put our documents together?
How's that worded again?
Well, it said grantor, and it wasn't using settler. I just threw that in because I was putting documents together. Grantor at times with capacity of beneficiary is the way it read off of a promissory note.
That's interesting.
That's what I thought, too. I hadn't heard anybody talk about that before. But what if we were to use it like in the capacity of grantor at times with capacities of special beneficiary?
Yeah, but here's the thing. Trustee does not have to reveal the identity of the beneficiary.
Even though it may be the same, or one and the same?
Yeah, that's a fact. It doesn't have to be mentioned. So I could be beneficiary on the private side, but on the public side, I'm trustee.
Interesting. Okay. I forgot to put that in my mind when I was looking at this.
Hey, Christian, it's JC. Good evening.
JC,
Yeah, it took me a couple times to log off and log in. Yeah, connectivity issues, I think.
Nice to hear you.
Good to be here.
Generating so
Nice
much
to be
energy that it's jamming the signals up.
Yeah, I have a couple questions. If I can have the floor for a minute.
Sure, go ahead.
So I asked about that birth certificate because to me that seems like the first step that we should all be doing in any way, shape, or form. So once we claim the birth certificate, are you going to want to have an unqualified signature on the front, or are you going to sign the front as a grantor?
Well, yeah, I probably should have said, a qualified signature on the front, yeah.
So we'll do a by grantor qualified signature, date on the front, flip it over for special deposit, like you discussed on the endorsement on the back. And then my thought is, under the rule of forms, we're going to keep that. Of course, we'll have an unique identifying number on that that will then be used for the UCC1 and the county filing of notice. Those are two public records. And my thought also is that we would then probably take that and get a certified copy by a notary, so they've witnessed that. We'll keep the original, unless you think for some reason that Rios needs that original. with the letter and the indenture.
Yeah, you're probably right. I think we should probably hang on to all our special deposit originals. That way we can prove that that's what we did. Send them the copies. They'd have to set up a special meeting or something, and I'll show them the originals that they want.
Right.
But they never will
as far as
possession.
But as far as the Rios is concerned, we'll send her our indenture along with a certified copy of the front and back.
We're not operating in that realm where we're supposed to give the tender of negotiable instruments in their original forms. Those days are over with. We're not operating in negotiable instrument law. We're not on the debtor side.
Right. So to Rios, we'll send her non-precatory language, the direction, the indenture, along with a certified copy of the front back with the endorsements properly done, and instructions. Now, we're also going to want to send her, if we're going to terminate the trust and extinguish all debt with that bond, then we're also going to probably want to send her a certified copy of the 3 because we transferred that to her, and I'm assuming that she's the agent to whom we'll transfer that.
Yeah. Right.
So we would not want to transfer it to anyone else, like, for example, an alien property custodian who might be holding all the debt titles?
I don't know who would be holding the debt titles, but I'm going to give the instruction for all the debt titles to be, withdrawn and redeposited or merged under trust. And probably you have to put both kinds of language in there. So it's kind of like a dual instrument that's probably going to be with enough colorable stuff that they can see in there that they can recognize that gives them the instructions what to do on their public side, and you're putting your private terms in there that expresses the trust and the terminology for the trust that does the same thing as the private side, but only under the private, only same as the public side as what we're doing on the private side. So it's kind of like both sides of the ledger being on one piece of paper with the instruction wise.
So once we get that off to Rios, she should do that. And then, of course, if she doesn't terminate and make disbursement per our instructions, then we'll have to go to some kind of enforcement. Let's leave that for a minute, though, and let's go over to the correction of the records. I don't believe that Rios is going to have the authority to make correction of all the records. So we probably have to call a DIB hearing and go to the Chief Technology Officer, for example, to make that correction.
Mm-hmm.
So in a separate mailing, separate letter, we're also going to want to address that. And my concern about sending things like that to the CTO is that if that person's not in the private, I guess they have the ability to operate in the private, so we just send that to them via registered mail again in the private and direct them to.
He heads of certain agencies or certain divisions that represent agencies that we want to notify and put them on record as being given notice. And we may have to work up a list of who we're going to send all these notices to.
Why don't we instruct her to do that?
Yeah, well, does she have the authority to do that? I don't know. So I might want to pick out maybe some certain key ones that I do myself so I know it's done. But I don't know if somebody would have to check in to see whether or not that's possible with her or not.
I think that's outside her scope of authority, and we'll have to probably draft a separate letter that we send in private, and maybe the main letter will be to the CTO for a DIB hearing, and then we can use that as we can carbon copy that to the agencies and let them know that the record's been changed.
I had a company one time, a business at a local bank, and that local bank put my deposit in somebody else's account, and when I wrote checks to all my other customers to pay my bills, I bounced I don't know how many checks. And I got calls back from my customers and complaining about, when I checked in, I found out that the bank had made an actual mistake. And I had that bank write letters to all my customers and straighten things up with what they did wrong. So if the bank accountant is, say, the IRS, they should probably have the ability to correct and send out corrections to all other agencies necessary to correct the records.
That's what my thoughts were, is to go to the commissioner of the IRS and instruct him.
Christian?
Yeah,
I have one more question, if I may. Floyd, can I have one more question?
Go ahead.
So in the event, say for example, you want to claim the birth certificate, but you don't necessarily want to terminate and demand your distribution or the disbursements of funds. You can still claim it, and that allows you to operate by it through the trust. So could you not also notify Rios that you've claimed it, you have access to it, and should that not also give you the opportunity to do any set-offs using that trust without terminating it?
Yeah, but I'm not sure whether or not you can get distribution out of the trust without termination of the account. It's kind of like it's maybe an all or nothing situation. So you want to skirt on the line and just take care of the birth certificate, and if there's something else, then I don't know. That might be doable. I don't know.
It was just a hypothetical if you did not want to terminate the trust, because the biggest question I have in this matter is, to where do you want to have the funds dispersed? I know that some people were talking about the legacy Treasury Direct account and making funds dispersed into there.
No, I want a trust fund to put the assets back into. If there's anything short of that, you're crossing it back over on the public side again. So I got to have a trust to put these trust funds back into. Now,
and what do you envision that trust being? What's the setup of that trust?
Oh, well, the same thing that was destroyed, the straw man account. Create me a new trust, except this time I'm creating a foreign situs trust, and deposit all these funds into that. And it would be some new name other than the straw man name. It's not the same trust fund. So that account, that straw man, he's been terminated. There cannot be any association with anything with that account because it's terminated. Period. Gone.
Are you talking about a 98 account?
Yep. Hang on a second, please.
No,
Go ahead.
I don't even think it's a 98 account. It may be just some private trust that nobody knows anything about other than, say, me and maybe a few other people.
So
Go ahead, JC.
I think along that line, does it make sense then that you, in your letter to Rios, assuming she has authority to do so, just give her a name of a trust, and tell her to hold funds in the name of that trust, transferring all those to just that name. And if she needs to set up another account for that name, feel free to do so, or direct her to do so. And then you'll recall those funds at your convenience whenever you feel like. That'll give you the authority then to make application or access those funds. But anyway, it's set up in a different name, and you can create that trust at your convenience. But just give her a name.
Right.
Okay. Thanks, Floyd and Jane.
So this would have to be some new entity that's got a clean slate. Now, if it gets messed up, it's because we knew we messed it up.
So you said entity. I'm sorry to step in again. You said entity. I was just picturing a name after which at some point you could create something else. You're not going to create a statutory name. It'll probably be some type of a private contract trust, but then you're going to need, again, like you said, some type of a commercially licensed bank account to monetize that and bring funds over into. Can you speak to the mechanics of that, perhaps? Will you see that trust being, how it's created,
Yeah,
and then how we can monetize that?
That new straw man account, so to speak, that takes the place of the one that was terminated, that's still on the private side. Then we're probably going to have to create another trust on the public side, which would be that new 98 account. And then probably connected to that would be an LLC, which would be the trustee over that trust. And there's where the checking account would be in the LLC. And that's a general fund for your use.
Then how do you get credits then from your new strawman account that you've so named into the LLC account, so you can spend them?
The agency is probably going to do that. Would probably be the Fed that's going to do the conversion for you via the Treasury, I suppose. So they're going to be your agent, cross over from one side to the other, create the credits on the one side, and the public side that is recognizable as everything else, and that way there's no hassles.
Okay, thanks.
Does anyone envision anything else?
I was just going to say that in noticing departments, that I think if you notice Rios and then Secretary of State and Secretary of the United States, then that should pretty much cover everybody.
Okay, there's some background noise. If you're not speaking, press *6 to mute out.
Can you hear me, Christian?
Yeah, go ahead.
Yeah, I just said that as far as noticing the departments, if we notice Rios, and then we notice the Secretary of the United States and the Secretary of your state, that should cover just about everybody.
Rios and who else now again?
The Secretary of the United States, Hillary Clinton, and then whoever the Secretary of your state, your own personal state is, wherever you're dealing, whatever state you're dealing in.
Yeah, I might want to maybe notify more than that. I might want to notify maybe all three branches of government.
Well, wouldn't the Secretary of State be in charge of noticing anybody like that?
I mean, he would acknowledge the fact, send notices to, say, the governor or the president and the attorney generals, both the state and federal.
Yeah, because you could give them an order in that notice to do that. And they're going to be notified that they're trustee.
Well, I don't think we should notify the Secretary of State because that's for foreign governments. Even though I know that United States Inc. is a foreign government, I think realistically we should be using the IRS and dealing with them and have them notify everyone because they know where all the debts are. And as far as the only thing I do see is possibly with Rios is once we notify her, I think my thoughts, I have to do the research, I don't know where to look, but I think she's the one that once we get out of the system, we can become our own nation within a nation. And then at that point in time, we can instruct her to give us the proper credentials to protect us to sojourn across this country or anywhere else we want.
Yeah, grant me safe passage through this fiction world.
Hello?
Yes, sir.
Christian?
Okay, in court cases, I've never seen a court yet that wanted to acknowledge that the uppercase straw man, if you will, is a trust. So even if you bring it to their attention, they just say, nah, that's you. So
I totally agree with them. It is not a trust.
It is not?
Never was a trust, and never will be a trust until you express it to be one.
Okay, having already expressed it.
Well, that would be a different story then. Then
Okay.
that was the invitation for you to drive the Mack truck through and prove the trust.
Okay. Well, with our UCC and federal notices and everything else, that is a trust.
Yes, you have to present the evidence to them that you did create a trust, and then you're the one that has to prove the trust. The one that makes the claim is going to have to prove a trust. They got the burden of proof.
Okay, so our public declarations, is that not sufficient?
Well, declaration only if you're grantor trustee within yourself, granting trust res.
Well, in my case, for example, I claim my mother on the birth certificate claimed that she created the trust and then subsequently did a transfer to myself as non-pro-tunc when I became 21 as the successor grantor. Is that not what we're trying to do?
The trouble is it's still not a trust until you express that to be a trust.
Well, I expressed it that it was a trust. And I laid all the parties to it.
You know, as long as you had the evidence to prove that it was a trust, then you need to be proven the trust.
And then the certificate of live birth is the return document acknowledgement.
Well, let's back up. You say they weren't saying that there was a trust, and was this?
I've never seen an attorney yet that considered that.
Well, you never will, because until you prove trust, it doesn't exist.
Okay.
Even the fact that it's been created maybe 10 years ago or 40 years ago or 50 years ago, however old you are, the fact that it's never been proven, in their eyes, it doesn't exist.
Okay.
And until I prove it to their eyes, then that's when it comes into existence. In their eyes, they're going to recognize it, but it didn't. It came into existence back when I was, say, born, let's say, the truth of the matter. But in their realm, it doesn't exist until you express it.
And at that point, to discharge a case, we take a certified copy of the BC and endorse front and back.
Yeah, you could do that, or just take the case itself and turn it into a trust and do the special deposit, turning that, and withdraw the case out of the general deposit and redeposit it as a special deposit. In that way, that'll merge the titles and terminate it.
Okay. One by one, we fill in the gaps.
Yeah. One by one, we created this mess, and one by one, we'll have to dismantle it. Although we could do it all in one fell swoop, I think. Just do a withdrawal of all the debt titles, all the general deposits that I've made all through my life. redeposit them under special deposit, which is the same as merging the titles and terminating the trust. That extinguishes the debt.
Yeah.
All debts, past, present, and future. So now that the distribution of the funds should be made, but there's no place to distribute it to, so let's create a new trust to deposit that remainder, that disbursement, put it in there. And then we can create another trust on the public side, the 98 trust, create an LLC to run it, get a checking account. They can generate the interest, do the conversion from one side to the other, put the credits in the one side, and let's all get on with our lives.
Christian?
Yes, go ahead.
Hello, this is Jeff in Washington State.
Hi, Jeff.
There are two locations in the country, in Pittsburgh and Minneapolis, associated with the Federal Reserve, that house fiscal agents. I'm wondering if these guys can be used instead of the brokers, because the fiscal agents are the ones that are responsible for converting all money.
Possibly.
It would be going through the Federal Reserve.
Have you done any research on that yourself, and have anything more to add?
We were doing some of this stuff with Patrick Devine last October, putting three things through the Federal Reserve Bank. They wrote back letters saying that they had no obligation to do it, but I'm sure it was because of the way we were doing it.
What do you think you were doing wrong?
We were going through the public side, and they want. I would think that you would want to go through their private side, and then they will convert over to the public. I can do some more research on it.
Yeah, that'd be. Bring it on the table next time.
Okay.
I got an email yesterday that someone was saying that the transfer agent goes back to the county where the birth certificate was issued.
Yeah, I have the original for registrar. But all he was doing was transfer the debtor creditor titles that we created. Anybody else with a question? Star 6.
Yeah, I've got a question for you, Christian.
Yeah, Pete, go ahead.
Yep. In the event of a court case, then if it's a court case and we're challenging the jurisdiction and we want to pull it into the Court of Chancery, what instrument are we using as the special deposit? Are we using the instrument that's come from the claimant's attorneys?
The charge or indictment or bill?
Yes.
Yeah, I think that's what I would be using, yes.
So we would physically mark that paper, and how would we then bring it into Chancery, or what would be going on there?
I mean, whether or not we're going to do the protective orders and the in-chamber stuff?
Well, that would be my aim, like to come in at Chancery, yeah, definitely. Just how to navigate the thing if someone receives a charge or a bill, and now they've got it in front of them, and they're claiming that as the So the property of the trust and themselves.
A scenario where we're going to give them more of the colorable causes of action on the public side, and then come in on the private side with the documentation to prove that the special deposit was made. A special deposit with a specific purpose.
Yeah, so in the event that it was...
Yeah, I think we have to simultaneously give them something on both sides. So it's like I'm trying to how do we colorably say we want to do a withdrawal on the public side of the charge, which would be the debt title, and we want to do a redeposit on the private side?
Yeah.
So the withdrawal could be the colorable action. And I'm thinking, there may be some kind of terminology we haven't quite discovered yet that would be equivalent to withdrawal, or maybe it might be just the withdrawal term itself.
Yeah, I was thinking of it as it's the claim as a special or segregated deposit. That is the withdrawal, because it takes it out of general into special.
Yeah, now maybe the special deposit I would have to put on the private side when I express that wording. But maybe on the public side is the withdrawal.
So what if we termed it as trust deposit?
On which side?
Public.
I don't know. It might... that deposit sounds like you were trying to redeposit it back in. That doesn't represent withdrawal as far as I can see.
Yeah, I see that. I see what you're saying now. Yeah.
And I don't know if I could put colorably where they're not going to get it. How do I express it on the public side that I'm doing a withdrawal of the general deposit? Because I probably can't say I made a general deposit and the general deposit is their charge. They're probably not going to look at that colorably. That probably won't fly. So we're probably going to have to come up with some kind of terminology that they're going to buy or recognize that is going to be withdrawing that general deposit out of that public side. Now, what that verbiage is going to be, I'm not quite, sure of yet.
I saw a definition in Black's Law, and it said equitable term, and it said that is sort of like demonstrating to the court that there is a trust issue at hand, and it needs to be seen in equity for the ruling to, be complete.
What was the term again?
I think it was either equity term or equitable term. I'll just pull that up now. Just give me 1 second.
I haven't had enough time to do research on withdrawal, but probably if you went through all the Black's laws, you could probably come up with a definition that's going to comport to withdrawal. That'll probably get us to where we want to be.
Yeah, I looked up withdrawal in 8th, and it's not in 8th. So I thought the equitable term looked rather good in that, it demonstrates that there is a need, and when I find you the definition, I think you'll agree.
Well, it's like everything is a bill and note issue, which is we're doing commerce, but yet they can't tell you that we're doing commerce. It has to look like you're being formally charged, but yet you're the one creating the bill and the note and giving it the validity to it. So we got to come up with some kind of withdrawal term that's going to be along the same lines.
Yeah.
And it might not be, say, withdrawal, that verbiage, but it might be something similar that comports to it.
So I said it was called equitable term, didn't I?
Yeah. I am looking under the word release, because release is really a merger of titles, and a release is also payment also.
Yep.
So I'm thinking a release might be the same as a withdrawal, but I haven't confirmed that yet.
Right, okay. I have equitable term, okay. Oh shit. It says C term number 5. Just give me one sec.
Because I think our problem is going to be on the public side to get something that they're going to be colorably recognized as to what we're doing. I think on a private side of that court, we can go ahead and use our terms we already know. We can do a redeposit, we can do an extinguishment of the debt and all that stuff. That I don't think we've got any problems on that side. We just have to find, I think, the last link, the magic word, so to speak, that we're going to use that's going to signify a withdrawal from the general deposit we made.
Well, I found equity term, and the definition is the period during which a court tries only equity cases.
And that's
so,
the definition of what again?
Equity term.
So a term would be a period of time, an equitable time?
Mm-hmm.
Yeah, a chance to enter into equity on the case to get the real ruling. And then we've got a special term, a term of court scheduled outside the general term, usually for conducting extraordinary business.
Extraordinary business.
Indeed.
Wow. Is that under pleading special matters?
That is under term in Black's Law. And it says court, cases, courts, 64 CJS, courts, I don't know what you call that squiggle, and then 119.
That's section. Section 119.
Section 119, yeah. So CJS, courts, section 119.
Juris secundum. What book is that?
That's in Black's Law, 8th.
Yeah, but does it say what book in CJS?
It says CJS Courts, section 119, so I imagine the chapter would be Courts.
Courts, huh?
Yep.
We got it right here. 119, section 119?
Yep.
Hey, Christian, under CJS, withdrawal is actually under confession of judgment.
Confession of judgment.
Yeah. Isn't that interesting?
Yeah. 119, special extraordinary term. In general, special terms of court are frequently held to be valid and legal, especially as against objections to the time of the calling or holding thereof. Judges are given authority to call and hold special terms of their courts. Okay, well, a special or extraordinary term. Wow. That could be useful. Order appointing. Statutory requirements as to the contents and entry of an order appointing or calling a special term should be complied with. Well, maybe we should put some orders in. Notice of a special term. Otherwise, then, the filing of an entry or an order calling it is not necessarily unless required by an applicable statute which is not construed to be merely directory. And what was that one, Christy, that you found again?
I found it under, excuse me, confession of judgment, and it's quite lengthy. It goes into, it looks like almost 1,000 pages of different types of judgments and decisions and cases and how they were overruled and how withdrawal was interplayed with some of the cases. So it's not just a description, it's many cases that are involved on this. Withdrawal was the word.
See if I can find judgments. There's judicial sales.
Christian.
Yeah. Who's
Hey,
it? Carlos?
Yes, sir. Hey, how you doing?
Good.
Good. Well, I just got back from Vegas, and I need you to know what Winston Shroud thinks about you. He thinks you're a real smart guy. Yes. He mentioned your name on the seminar. He says, Christian out there is doing some trust, some good old trust. And he said something else, but he's a real bright guy. He's doing something good. And I told him, you got it, baby. So we're on the right track. That's what I'm trying to say to everybody. And you got to see where it's coming from. This guy, he's highly knowledgeable. I've never been to his seminars, but I like to experiment with everybody or try to find out exactly from the horse's mouth what their plan is, what they're trying to do, or what are they teaching. So I says, what can I lose? A couple of days in Vegas? I had a good time. That's all. I just want to make sure. It made me feel good. What he said about you made me feel real good. That it makes sense that everybody's on the right track on this team. I had to tell you this one. I think it was real nice of him. Real nice of him. All right, Christian, that was all. I just got here right now.
How much trust stuff did he talk about?
He did talk very little about trust, but he's talking more about trust, and that's when your name came up. Because he did talk about trust. He was talking more like a land trust. More like a land trust. And I noticed something, which I bought one of his CDs, and I noticed something on trust, and somebody asked him, how do you put a property into a land trust? I was surprised. He says, I don't know. He says, oh my God. Well, I guess he can't know everything, right? So, but he's still one of my heroes. But he did not talk a lot about trust. Probably about trustee, who's the trustee. But he did mention a couple. I'm sorry?
Did you get his number? We'll call him and we'll educate him.
Well, I didn't want to go that far. I did tell him. I went up there and shook my hand, and I told him I knew you. And I told him, he didn't hear me. And he says, what did you say? And I told him, I said, you're my hero. He says, oh my God. He says, well, I mean, he's a good old guy. But he's got some real interesting documents when you want to, instead of substituting the trustee, I'm talking about debtor creditor system. When substituting trustee, he puts down a form which says successor trustee. I mean, try to change names a little bit, titles a little bit, so that you won't have a problem when you try to register in the county. Did I get through with that? I mean, is it clear?
Say that again now.
When you try to replace a trustee as a debtor creditor, you're going to fire the trustee, right? So they don't sell your home. He has a form that he names it successor trustee. Same thing as having a trustee, right? But that way they'll record it in the county without any problems.
Right.
Just by the name, it's just what they want to see in the county, especially in California. But I had a good time. I had a real good time. But no.
Sing along with him with his.
I'm sorry, I didn't hear you.
Did he have like a little musical get together before the night before?
No, it was only Saturday and Sunday. No, it wasn't like a welcome thing, no.
Oh, it wasn't?
This was some kind of a 2-day only for members only. I'm not a member, but I paid my money and they gave me a 3-month membership. Because I wanted to find out what he was about. I mean, I'll go to all the seminars. I mean, even though I believe in your system, even though I want to follow your steps, I still do not take anything for granted. But we had a good time. My brother.
Yeah, I'll keep an open mind to everything.
Yes, I have an open mind, and I don't take anything for granted. Not anymore. Not anymore. After what we saw we went to court the other day, when a friend of ours that my brother went as a translator to a friend of ours that they're trying to kick him out. So I told her, if you don't want, they lifted his stay on the bankruptcy 13, and I told her you have to file bankruptcy 7 in order for you to stay on the house. As soon as she stood up in front of the judge, without even looking at the documents, she says she's not a party in interest in this property. He knew the whole story without even looking at those documents. My brother says, this is plain fraud. Plain fraud. I mean, this guy knew everything. He even knew his wife didn't have any interest in that party. Because she doesn't. She only lives there. But San Bernardino County, down here in LA, is the worst. The most corrupt judges we have up here. And I have first-hand knowledge of this thing going on because I go very often down there. But anyway, I thought I had to tell you that you're out there, Christian. We feel proud of you.
Okay, well, thanks, guys.
No problem.
Hey,
you were
Christian.
on the Saturday show, weren't you? Did you listen on Saturday?
No, I wasn't there in Vegas.
Okay, you missed a big one.
Oh, my God. I hope you recorded it.
Yes, I did. In fact, I'm going to probably give this one out to everybody just to get the message out there.
Great. And I knew, I rarely miss anything, but I have confidence that Chris or somebody else is going to record it. You know, I can always get back to them. There won't be no problem. But I had the sense that Saturday was going to be a good one, but I
that was
confidence.
NTT and the nature of deposits, and I went over special versus general deposit.
Right. Yeah, he didn't talk anything about special deposits, and he was talking about trust. But I didn't want to butt in there and tell him because he was having a good show. He had a full house. I mean, there was 180 people there, and he was charging $300. And they were people from Canada, and one of them from Switzerland. They flew in there especially with him. We got to give him credit. We have to give him credit. Yeah, well, I hope I get that. Are you going to have it available through how? The recording?
Well, probably you'll have to ask me for it. If you ask me for it, I'll give it to you.
Okay, thank you. Sure will. All right, I'll kick back. Thank you.
It's already on the For Shared site.
Okay. How do I get to the For Share again?
Are you on the Skype group?
Yes. I'm Trust Law. Remember, I changed my name.
Well, let me give you the authorized version.
Okay.
Then you can post that one.
All right.
Because all the unauthorized versions are not authorized.
Did we talk dirty in there or what?
They got the disclaimers in them and the setups for the lead-ins and things, and probably some brush-ups and amplifications and things.
Yeah, and also I did hear about I came in late, but I did hear that you mentioned something that the trustee when we're talking about a trust, he doesn't have to tell who the beneficiary is. I only seen one case when this guy I did a land trust for this guy, and we had everything in line, but they compelled them to disclose the beneficiary. And once they compel you, you have to. As a trustee, you have to. I told him you have to. There's no way around it. So we did. I mean, he didn't lose, but you have to. Once they compel the trustee to say who's the beneficiary, he must say it in court. I seen it. I had personal knowledge of that.
That's going to be public.
That may
I'm
be
talking
on
about a
a,
land trust. No, let's step one step.
that'd be a
Land
public trust, maybe.
Yeah, land trust only. Land trust only. I'm sorry. I should have mentioned that before. Land trust only.
Hey, Christian.
Yeah,
can
I
I
got
read
the judgment.
I'm sorry.
What was that judgment again? Under judgments?
You were talking about with, excuse me, CJS. That would have been withdrawals, and that would have been confession of judgment.
Confession of judgments. Okay.
But I found something really interesting here. This is the Federal Reserve Banks of Chicago's definition of bank and deposit creations. It says depository institutions, which for simplicity we will call banks, are different from the financial institutions because they offer checking accounts and make loans by lending checkbook deposits. The deposits creations activity, essentially creating money, affects interest rates because these deposits are part of savings, the source of the supply of credit. The bank creates deposits by making loans rather than handing cash to borrowers. Banks simply increase balance in borrowers' checking accounts. The borrowers can then draw checks to pay for goods and services. These creations of checking accounts through loans is just as much a deposit as one we might make by pushing a $10 bill through the teller's window. All of the nation's banks able to increase the supply of credit in this fashion, credit could conceivably expand without limits. The bank creates checkbook deposits. They create money as well as credit, since these deposits are part of the money supply. That's right out of the Federal Reserve Bank.
It sounds like what is the one? The Fed publication, the one on money.
Mechanics.
Modern money mechanics.
Yep. This is full of good news right here.
Hey, I just found the withdrawal Sigma. The group pointed out that it was in Black's Law 4th, and it says withdraw, to take away what has been enjoyed, to take from. And then withdrawal, remove of money or securities from a bank or other place of deposit.
Chris, how did you have that stated there under the judgment by confession or confession by judgment?
Let me see if I can find it again here. This was under corpus juris secundum, under the category of withdrawal, and where it took me to was the category of confession of judgment, of which there are several cases that it reflects withdrawal as being the definitions that they're describing. But the key component that I was pointing out is that I located in confession of judgment, which is a term that we use quite often.
Right. It might be in there someplace. I got the judgment by confession section here.
Yeah, it's pretty immense. Mine seems to be, it looks like close to, I don't know, the little bubble on the side is just like, it's like one little teeny thing here. It's got to be 1,000 pages long. Doesn't even move the bubble when I scroll down. But there's got to be a better definition than that.
No section reference number or anything like that to.
Hold on.
What
it
might
goes in. section, it says 107, then 146, and that would be corpus juris secundum, complete reinstatement of the entire, oh, you don't need that part. Where is it?
107, you say?
Yeah, it said 107 at the top, and then it had a break between that and 146. I don't know if that was the exact location of this.
Does it list 107 as being authority and duty of court?
I'm looking. Because they've got all these other subtitles in there. I can't confirm it. But it does say 107.
What was the other section? 107 and something else?
146. Oh, it says volume. Do you know how to do a Roman? It's XLIX. What is that? That's what, 69? That would be in Roman numeral?
49, isn't it? With the X before the L takes away 10 from the 50. The L is the 50, so I think it's more like 44
49.
actually. 44, because the I is before the V, is it? Did you say? Or the I before the X?
It's XL and then IX.
49.
So wouldn't that be like 49?
Yeah.
Yeah.
49.
49.
All right, this is volume 49 I got.
Okay. So you must be in the same category.
Okay, what was that section number again? 140 something or other?
It says 107, and then it has a break, and then it has 146.
146.
And,
maybe that's through 107 through 146.
yeah, that's highly possible. By the way, Christian, the law bookstore out here is closing this next month, and I'm going to call him tomorrow to see if he's got any volumes of the Corpus Juris Secundum for sale. And if he does have volumes of this, would you have an interest in buying a set?
I've got a set. What I need is
you've already got a set. Oh,
you're lucky.
Huh?
I've got a complete set. Yeah.
My God, you're a lucky guy. The other one I want is jurisprudence.
Yeah, Amjur.
Amjur, yep. But I scrolled all the way down on this 107 through 146, and once you get past all of the acknowledgments, it goes into the section talking about confession of judgment, and some of the cases that they have here actually have withdrawal as part of their cases. I'm not familiar with the Corpus Juris Secundum that much, so you have to forgive me. Still trying to get to the bottom there.
Summers?
Yes.
Chris Summers?
Yes.
Yeah, you could be getting into many cases that deal with attorney withdrawals from cases and, the basic court operations that have to do with withdrawal from cases. That may be 900 of the 1,000 pages.
Oh, man, this thing is immense. They even talk about the writ of error coram nobis and actions to review judgments, confession of judgments. This thing is immense. It's just loaded. Of course, this is kind of getting off topic matter too, but very impressed with all the cases they've got in here.
Well, in mine it lists judgment by confession starting at section 138. And then forward. I don't know how far it goes.
I'm seeing this. I can't find the one on withdrawal here, but there's so much of it.
Yeah, that's interesting. What you just said there. Whoever was talking, that he said withdrawal of and it doesn't make any difference what the case is. It's withdrawal by attorneys. Is that what your understanding is?
Yeah, this is Jeff at Washington State. I did some research on that, and I came across, I was in Corpus Secundum Sunday, and there's just tons of stuff having to do with court case procedure and withdrawal. Withdrawal of motions, withdrawal of evidence, withdrawal of attorneys, and it's just, you know, it's just immense, like Summers is finding.
How about withdrawal?
So I gave up. I gave up on the word withdrawal.
How about withdrawal of cases? Anything there?
Jeff?
Yep.
I think
anything on withdrawal of cases completely?
Yeah, that's what they had some Latin terms with that, like quorum nobis, like that. Those are special writs for removing to another court, withdrawal to another court.
What was the quorum? You timed out there. Quorum nobis?
I think
is that what you're saying?
Yeah, quorum nobis is one of them. I've come across about 5 or 6 different old methodologies that were used in the common law for withdrawing from cases.
Mm-hmm.
And they have, all these Latin names. I'm kind of familiar with them. So when I came across them in the CJ, I just started realizing that I was starting to get into a dead end.
Well, it might not have been such a dead end after all.
Yeah, well, I never found confession of judgment.
Because we're looking for a word of terminologies that we could use for withdrawal from a general deposit, which would be the charge of the case in the court. And
yeah, I think we're going to find another number. Another name.
If we could comport withdrawal into some other name that would be recognizable as the court, that would be tolerable.
Okay.
And then I think we have the ability to withdraw the cases out of general deposit on the public side.
Well, I'll go back in there Wednesday after your call on Tuesday. Go back to my university source that has the complete 2008 Corpus Juris Secundum, and I'll look into some of those old common law names.
Yeah, there's words in here I don't even recognize.
Well, when they took away the common law, they took away all those terms.
Yeah.
I understand you can still use them. There's still writs that are available to be used, but it's very rare that the judge will actually let you use it.
Appellate court or Supreme Court or something like that.
Yeah, you can do it in there. Well, even habeas corpus, they probably tried to take that name out, but they couldn't. But that goes way back in law.
Yeah, it goes back to at least 1215.
Oh, yeah, a long time ago. Yeah, Magna Carta. That's probably why they couldn't take that out, but they took everything else.
Let's put it this way. They look like they've taken everything out. They just stuck it on the other side and trust.
Right.
I was looking at a book by Austin Wakeman Scott earlier. It was, let me just see.
Well, here's one on definition of withdrawal of benefits. That might be interesting.
Fundamentals of procedure in actions at law.
What year is
Is that
that?
like 1919?
Yeah, I think it is 1919. I've just opened it now. It's Austin Wakeman Scott. Let's see. 1922, it went into the Library of the University of California. I think it'd take some research. There's 200 pages.
Probably have to come up with a more modern term, though.
Okay, restate what you were asking for with the withdrawal. That was out of special deposit, or what was the, restate it, please?
Okay. Give me a minute, I'll find it here. We'll go over it.
Well, you started with taking it out of corpus juris, right? Isn't that where you first found it?
Yes.
Mm-hmm.
So there's cases under that.
Right.
We can go looking into those cases. Find out how they're using withdrawal.
Oh, there is some cases on withdrawal in Black's Fourth. I didn't think that was important, sorry.
Okay, this is under Section 285, which is changing character of deposit. So it says, in general, a special character of a deposit may be changed by mutual agreement of the parties, but not by unilateral action. To change a general deposit into one of special character requires a contract. Such a change is dependent on the intent of the parties. The fund, at least in legal contemplation, must be withdrawn from the general deposit and redeposited with and accepted by the bank under a new arrangement. There must be some act to segregate the funds for the particular purpose. The bank's issuance to its depositor of cashier's checks to the extent his deposit does not change the relationship of debtor and creditor, nor make the transaction a special deposit. So that was in the first paragraph. So we need to, it must first be withdrawn from the general deposit and redeposited with and accepted by the bank under a new arrangement. So if the bank is the court, so we need to do withdrawal first and then redeposit it under a new arrangement.
And there's 5 cases listed under that section that we can refer to.
Yeah, they list number section 85, let's see, 84 also.
Okay, here it is. I think this is what we're looking for. A bank is an institution usually incorporated with powers to issue its promissory notes intended to circulate as money, known as bank notes, or to receive the monies of others on general deposit, to form a joint fund that shall be used by the institution for its own benefit for one or more of the purposes of making temporary loans and discounts, of dealing in notes, foreign and domestic bills of exchange, coins, bullion, credits, and remissions of monies, or with both these powers and with the privileges, in addition to these basic powers, of receiving special deposits and making collections for the holder of negotiable paper if the institution sees fit to engage in such business. Now it's getting pretty close.
There wasn't anything mentioned about withdrawal there, was it? Oh.
Actually, it's implying it because what they're doing is they're converting the money from one system to another, which they actually said general deposit, and when they get finished talking about it, it's going into a special deposit. I'll post that on the Skype for everybody. And
any words, reports to that though? Withdrawal.
Let me just see here. There's another section here. Undertakes to repay them.
Chris, that sounds like the bank has the authority to do it rather than us. We're looking for our authority to withdraw.
Yeah, but in some cases, you know, the reasons why we got where we're at is because we're using their language.
Yeah. General deposit, not knowing that we could have done otherwise.
Well, what
Since we
what I
made the
did is
deposit, we can make with a withdrawal, and then we can redeposit it with a special deposit.
That's right. And this language does help. This was based off of a case. Let's see what the case is. In 1899, the United States Supreme Court used these words to define a bank. So that was what their definitions of a bank was.
I think I found one called Geofail. It's Geofails, and this is from Austin Wakeman Scott. And it says, "It is astonishing how irretrievably fatal was the effect of a mistake in any step in an action at law in the periods when the common law system of procedure was reaching its maturity. Mistakes made by the clerks in recording judicial proceedings were equally fatal until Parliament intervened and in a series of statutes of amendments and geofails gave a moderate measure of relief. With respect to mistakes made by the parties, Parliament was slower to give relief until 1585, a defect, even of form, could be taken advantage of not merely by a general demurrer, but after verdict by a motion in arrest of judgment or in the upper court on a writ of error." And then it says, "Moreover, the courts were extraordinarily reluctant to allow the parties to retrieve their mistakes by amendment. In the days of the yearbooks, it was quite different. The pleadings were oral statements made by counsel in open court. If either counsel made a mistake in stating a cause of action or defence, nothing was simpler than to make a new and more accurate statement when attention was called to the mistake. When, however, in the course of time, written pleadings were introduced, the courts took a sterner attitude. Even Blackstone, to whom the common law procedure appeared almost the perfection of wisdom, complaints of the refusal of the common law judges to give the parties permission to amend their pleadings." Does that sound about right?
Was there anything that's really talking about withdrawal?
Well, it's saying that when a mistake's being made, then you can come in with a more accurate version. So I would think that.
Kind of like an amended pleading, though. That's what it's alluding to. We don't want to really amend it. We want to withdraw the whole thing.
Oh, okay. You're rewriting history, Christian.
Well, Carlos, did they did a DVD on that Winston Shot one, didn't they, Carlos?
Christian?
Yeah, Carlos, are you out there?
Usually takes them a minute to get on the line.
Yeah.
Yes, I'm here.
Hi, Carlos. They did a recording on the DVD for that seminar, didn't they?
Yes.
Okay.
Where they mentioned your beautiful name, yes. Christian.
I was going to say, was the tape running when they mentioned that?
Yes, sir. Yes, sir. Me and my brother felt we were proud about you.
Okay. Well, I'll have to get a copy. I'll have to get a copy.
You know what? Once it comes out, I'll make sure you get it.
All right, great. I appreciate that.
You can count on it.
Christian.
Yeah.
This is Al. I went about a year ago. I went to a Winston Shroud seminar in Orlando, and they do tape. They do send a courtesy copy of the recordings to the people that go to the seminar.
Right.
And I think you can order and get copies of, ones that you haven't been able to go to. But I have his information if you need it. I can bring it tomorrow.
I'm gonna get it. So you can count on it.
Okay. Yeah, you're gonna get it. You probably just make a copy and just.
Yeah. I think they're gonna mail me a copy, and even if they don't, I'll just buy it and then send it over to you, Christian.
Okay, appreciate that.
Don't even bother looking for it.
I'll get this came up lights, recognition of my peers.
Oh, yeah. Well, you know what? He's one of the biggest names out there. He's one of the biggest.
Well respected.
For him to recognize you as a good guy on the trade, I mean, that's something. I told my brother, Christian is going everywhere now. We feel proud of you.
Well, we'll have to put a seminar on next.
Yes, that's what I was thinking about. You should put out a seminar, and so we can all meet each other and help you and help us and help each other. That's the point, right?
Yeah.
Right.
Make it private.
I have a question. Sorry to interrupt, but I wanted to catch Carlos Christian.
Sure, go ahead.
Is Carlos?
Carlos is running around. I'm just kidding. I'm here.
Carlos, is Carlos the one that I could talk to about that's been through or the divorce proceeding?
Divorce? No, I have. Yeah, I've been divorced once. No, it's not me, man.
What I mean is, you could tell me some things.
Regarding divorce, not really. I haven't done it. I was
speaking about. Make reference to there was a Inter Vivos trust that somebody was splitting up some funds and they want to put it in there, and it had to do with the Inter Vivos trust, I believe. Yeah,
I think she's talking about probate and getting stuff out of your name and keeping it private.
Yeah. Do you have an email, Carlos, that I could contact you through?
Yes, ma'am.
Okay.
It's TRUST. It's capital T, then small letter RUST. See, and then trust law, L, capital L, A-W. I'm not a
all one word.
One word. Trust law, one word.
Yes, that's it. That's all you need in Skype.
Okay. That's all I need to do is just go through Skype on that.
Yeah, I had like 20 persons interested in those documents and in finding out more about it. So, which is good. I feel good. If I can help someone, it makes me feel good. Which is fine. You're welcome.
Okay, and then when I contact you through Trust Law, when I do the search to get to go through Skype, then you'll accept it, I guess.
Yes, I'm gonna accept you. As my study buddy. Yes.
Okay, or do you need to know one of the words?
No, just tell me I'm here. I'm right in front of my computer now.
Okay.
Do it now. Okay. Thank you.
Thank you. Thank you, Christian.
Christian?
Yeah.
My brother asked me. We were coming from Vegas today, and he asked me, "Does Christian know how to put or place a property in a land trust?" And I says, "I have no idea, but I'll ask him." Do you?
How to put it into a land trust?
Yes.
Well, I don't know exactly all the detailed steps, but yeah, I could probably do it.
Yeah. Well, let me clarify this for everybody. Let's say you were gonna quit claim or did a property to me, right? Christian Waters hereby grants to Carlos Aguirre this property, right? Now it's mine.
Right.
Right?
Right.
Now you're gonna put it in your trust. Christian Waters hereby grants this property to this Mickey Mouse Trust. Well, you can name it whatever you want. There it is. That's all. That's all it takes. Grant deed, 1 page. Done. See, the reason I brought it up, because my brother asked me, how do you do that? It's very simple. And he says, does Christian know? I'm sure he does. If not, I think he can figure it out. But because I had that question more than once, that's why I brought it up. So it's real simple. Quit claim it to the trust. It's over. See, now you don't own it. The land trust owns it, right?
Mm-hmm.
The simplest thing.
You can also do that by assignment too.
Yeah, but we're in California. You need the highest title, which is a grant deed. You say grant deed. Grant deed has a highest title, has possession, or a warranty deed, or quick claim deed. So let's do it the right way. Do it through a warranty deed. And when they sell your property, if they sell your property, they only sell in a trustee sale, they only sell the interest. You still have a highest title if you know how to find it.
Yeah, what is it, grant deed, trust deed?
No, it's a grant deed. It's a grant deed or a quit claim. Quit claim, you just quit claiming the interest. Grant deed, you have the highest title there is in California.
Yeah, well, I think grant deed's the same as a trust deed.
Well, yeah, when we talk about properties here, when we're conveying properties, conveying in or out of a name or a trust, we use a grant deed or a quit claim in California.
Yeah, but
some states use warranty deed.
You said the quit claim didn't have as higher title than the grant deed, though. You said in California?
In California, see, when you buy a home, it doesn't say quit claim. It says grant deed. So we have to stick to the guns, right? I always, I mean, I didn't make it up. I mean, I've been studying this, and they told me grant deed, when they sell a property, they do a sale, a trustee sale. They just buying a portion of the interest. The interest, you have the grant deed. You don't know, but you have a higher position than whoever buys the property.
Yeah, because really the beneficial title is still in the county, and
right.
You're just taking the legal title and shifting it around.
Right. Well, you're going to shift the legal title to whoever you want, to another person or to a trustee or another trust, whichever. Yeah, but it's interesting, which I think it sounds confusing, but it's not confusing at all. It's real simple. Just pretend you're going to quit claim your home to somebody. Instead of quit claim to somebody, quit claim it to a trust of the name of their choice. That's it. You don't even have to use you don't even have to do the whole package. Just do that, and if you get in trouble and then you need to change around the beneficiary or the trustee, you can do it in 5 minutes. You don't have to go do any right and wrong. But the biggest secret of it all, the biggest one I have seen, not many people know about it. When you convey the property in a land trust, it becomes personal property. I had the government. My brother had a surgery. The government wanted some money from them. They were asking him because the property was in our land trust, and I told them. I wrote a letter back. It says, this property was conveyed into a land trust about 1.5 years ago. 50%, right? Beneficiary, and this is personal property. I will not partition my 50% of this personal property. It's personal property. They never bother me anymore. Mm-hmm. They never bother him anymore. They went through another subject trying to get money through some other method, but not through a land trust. I will not partition because it is personal property. Case closed. I mean, it's not a silver bullet, but it's a lot better than nothing. Trust me. All right, I'll let somebody speak. Because I guess I can get
Carlos, you must have an awfully large mattress.
Why? Oh yes, you mean for my
for your beneficial titles.
Christian, check this out. This is what I do.
You told me. You don't say it again. You don't have to say it again.
Okay. In case somebody just wanted to hear it. Yeah, well, my mattress. See, I don't need any springs in the mattress. I have documents in there. I'm just kidding.
You sound like me, Carlos.
What's the goal? The goal is to make it work, right? And it's working, and it's hiding. And there's one more special feature. I'll bring it up later. So that
might as well bring it up now.
Well, I got to think about it. There are four good things about it, because I think Eric asked me about it. What's good about a land trust? All right. We were talking about land trust. He says, well, first of all, you're going to get it out of the public, which is fine. I went through a lawsuit. I already said this before. I went through a lawsuit. They could not put a lien on none of the properties. They only put a lien on the property where I live because they assume, between quotes, that I live there, right? But they're not sure. But they could not put a lien. And I told them, if I die, there's no probate because the owner hasn't died, and the owner is the land trust. I died, and then they have a beneficiary who I can change every minute if I want to. I don't have to go back and forth to the county. See, once I did that first step, I hereby, Carlos Aguirre, granted to Las Vegas Trust. It's done. I'll leave it there forever, and I can change it every 5 minutes. I don't have to go back to the county. That's a beauty. And nobody has to know. When nobody has to know, we have a trust, right? That's it.
Right.
But if I come up with good tips on those land trusts, because I did have more than, I think, about 19 persons call me and wrote me, which make me feel good. They had, I guess they didn't know about it. And it's a little confusing at the beginning, but it's not confusing at all. But they're welcome to call me if they want, or Skype me.
Thanks, Carlos.
Fair enough. No, thank you. Thanks for taking us by the hand.
Well, if we got some good researchers out there, see if we can find some other words that would comport to withdrawal and redeposit that would be along a more modern verbiage that would express to the court that what we're trying to do.
What would special demurrer mean to you, Christian? I'm looking for it now, but I can't find it.
Special what?
Demurrer. Oh, it's under D.
Special demurrer?
Yeah.
I don't know if a demurrer would be what we want or not.
Isn't a demurrer an objection?
It's like an answer back, isn't it? And I'm thinking, because it's under special demurrer, then demurrer, inequity, an allegation of a defendant which, admitting the matters of fact alleged by the bill to be true, shows that as they are therein set forth, they are insufficient for the plaintiff to proceed upon or to oblige the defendant to answer. So, special...
Has anybody looked up the definition of specific performance?
Yeah, it's an equitable remedy.
I got the first edition Black's Law definition here, if you want me to read it.
Go ahead.
Performance of a contract in the specific form in which it was made, or according to the precise terms agreed upon. This is frequently compelled by a bill in equity filed for the purpose. Second story, Ec. PL. Section 712 et seq. The doctrine of specific performance is that where damages would be an inadequate compensation for the breach of an agreement, The contractor will be compelled to perform specifically what he has agreed to do. Sweet. Are we looking to enforce specific performance to whatever contract we write up?
How's that tying with withdrawal?
Well, we're going to ask them to withdraw in kind, whatever it was. In kind was give me the speeding ticket and give it back to them. Specific performance by the trustee.
Well, really, I wouldn't want to be giving them back to them unless it was by special deposit. So.
Well, that's what I'm sorry, that's what I meant.
The definition of special demurrer, do you want to hear this one?
Yeah, go ahead, Pete.
Yeah. A special demurrer goes merely to structure or form of pleading which it attacks, and usually only to some portion thereof, and must distinctly specify wherein defect lies. Huff v. Palmer, 356, Illinois, and Cameron v. Evans, Securities Co., 119, California. And then it says, it is one which accepts to the sufficiency of the pleadings on the opposite side and shows specifically the nature of the objection and the particular grounds of the exception. See Dairy Region Land Corporation versus Harding in Texas, and Johansson v. Cudahy Packing Company, 107, Utah. So while a general demurrer on specific grounds relating to different allegations of bill may be called special demurrer, which attacks different parts of bill specifically,
$2 to $3 billion a year would basically triple my...
While general demurrer on specific grounds relating to different allegations of bill may be called special demurrer, which attacks different parts of bill specifically, such demurrer fails if bill is good as pleading and remaining allegations are sufficient to support relief prayed. Forcum v. Symes, and that's 106, Florida, I think. And that's pretty much it on special demurrer. It says, a demurrer, by federal rules of civil procedure, demurrers, pleas and exceptions for insufficiency of a pleading are abolished. Every defence in law shall be made by motion or by answer. Motions going to jurisdiction, venue, process, or failure to state a claim are to be disposed of before trial unless the court orders otherwise. So is it disposed, the word we're looking for?
And that might start looking away because I'm looking under withdrawal here, and it says see discharge. Withdrawal and discharge can be comported together. I think we might have a bingo.
Ooh.
What was that word again, Pete?
Dispose.
Dispose? Mm-hmm.
Yeah.
So it could be something like maybe also it's got renunciation, retraction, discharge. something like that, because discharge looks pretty good, because if a discharge means withdrawal, and discharge in the public realm will mean, you know, hey, it's been taken care of. But on our side, a withdrawal would be we're taking it back. The act of taking back or away, or withdrawal of consent, example. And then under the removal of money from a depository, withdrawal of funds from a checking account. But discharge looks kind of promising.
Yeah, I've got discharge up now. Any method by which a echo
Muted. Unmuted. Muted.
All right, Pete, come on back in. Press *6.
Yeah, I've got discharge. It says
Unmuted.
which a legal duty is extinguished. The payment of a debt or satisfaction of some other obligation. And then
If you're not speaking, press *6. We've got some background noise there.
Muted.
So, discharge, a noun, number 1. Any method by which a legal duty is extinguished, especially the payment of a debt or satisfaction of some other obligation. And then bankruptcy, which is number 2. The release of a debtor from monetary obligations upon adjudication of bankruptcy. And that's a discharge of bankruptcy, which is a release. Or it says CF, release, number 1. And number 3, for discharge, the dismissal of a case. And number 4, for discharge, the cancelling or vacating of a court order.
Yeah.
And number 5.
If you can get one that ties in real good with withdrawal now. Because it says withdrawal, see parliamentary law, see discharge 9.
Discharge.
If we could get a more, if we could get a definition under discharge that ties in with withdrawal, that's what we want.
Number 9, parliamentary law is a motion by which a deliberative assembly, having referred a matter to a committee, takes the matter's further consideration out of the committee and back into its own hands, which is withdrawal. Yeah. Also termed discharge a committee, withdrawal - discharge.
Christian.
Yeah, go ahead.
I got in Black's Law 4th as a noun. I don't know if this applies, but the word means the act or instrument by which the binding force of a contract is terminated. Can that still apply to a trust?
Yeah, well, I guess maybe. I think that would be the debtor creditor contract.
Well, that's under discharge, so I don't know if that's a colorful. Irrespective of whether the contract is carried out to the full extent contemplated, in which case the discharge is a result of performance.
It's like, okay, we got House Joint Resolution in there which mentions discharge. That might be the word we're going to be using, because discharge probably comports to withdrawal. So here it is on a House Joint Resolution which was talking about discharge, which actually means withdrawal, and we should be withdrawing all our general deposits, but colorably they're going to look at it, it's going to be a discharge.
I have a definition here. Reclaim RECLAIM, to claim or demand back, to ask for the return or restoration of a thing, to insist upon one's right to recover that which was one's own but was parted with conditionally or mistakenly, as to reclaim goods which were obtained from one under false pretenses. Reclaim.
It's funny he brings up reclaim, because I was thinking earlier that if we're going in there as trustee, why not do a disclaimer?
Well, I don't know if you want to do a disclaimer. You wouldn't be trustee then.
So you'd have no business being in the court?
Yeah, but they'd have a charge against somebody. The straw man account.
Got you. Yeah.
But then if we come in and make a reclaim instead of a claim, or a counterclaim or a re-counterclaim, something like that, you know. But I'm kind of liking the word discharge because, you know, discharge is House Joint Resolution, and it also means withdrawal to a certain extent, and I might want to just put an order in for withdrawal of the documents and discharge.
Wouldn't it be both?
Yeah, yes, it's both. Yes, it's a withdrawal and simultaneously a discharge. So the withdrawal could be, you know, under banking term, withdrawal of
unmuted
general fund.
How about an equitable withdrawal for discharge?
You know, because when they give you a court indictment, they give you a charge. So you're going to do a discharge. You're going to do a withdrawal.
Are we coming out of law now, moving into equity, or what are you thinking?
Yeah, that's the whole idea, yeah. But I got to give them some kind of colorable term they're going to recognize. And I think discharge probably would be a good word.
Hey, Christian, I'm looking in the Encyclopedia of Banking and Finance for discharge, and it refers you to Negotiable Instruments Law, which is UCC Section 3601 through 608. And they're using words like payment or satisfaction, cancellation and renunciation.
That's withdrawal. Renunciation's under withdrawal.
Right. That's
Go ahead.
3605. Might find something in there.
Yeah, because the fourth definition under withdrawal was renunciation. Withdrawal from a conspiracy to commit arson was the example, but there may be others. Let's look up the word with renunciation. Number 3.
Why can't you just use the word withdrawal?
Because I don't think it's colorable in court. Why are they going to withdraw? Unless withdrawal means discharge.
What about withdrawal of interest?
Charge.
Well, it says here under definitions for trust law, in common law legal systems, the trust is an arrangement, blah blah, and it uses the word withdrawal in the trust terminology.
Yes, I know, but we need a colorable public side court word.
How about satisfy? In 3603, it talks about payment or satisfaction.
What about dispersion?
I was thinking more earlier about the two terms I was thinking. I meant, like, is it possible to do discharge and reclaim?
I think we want to do withdrawal and discharge unless we can get a better word for discharge.
So that's your public and private?
Yeah, the private would be the withdrawal. Public would be the discharge.
Then we have to fix it back up again, but with the reclaim, right?
What's wrong with set-off?
I believe, well, let's see, set-off versus offset. Yeah, set-off's on the public side, same as discharge. Offset would be on a private. Well, the reason why I like discharge is because discharge is in House Joint Resolution 192. And they always charge you with an instrument, so we discharge the charge with a discharge, which would be a withdrawal.
And it's a remedy.
You've got disposing clause, which is the clause of the U.S. Constitution giving Congress the power to dispose of property belonging to the federal government. And that's U.S. Constitution, Article 4, Section 3, Clause 2. And that's under Corpus Juris Secundum, Section 101 to 106. I don't know if it's the 58th volume or something like that. So if you're the grantors of the Constitution and you give Congress the power to dispose of property belonging to the federal government, maybe only in a federal court, I don't know, but that's disposing clause.
Discharge by operation of law is where the discharge takes place, whether it was intended by the parties or not. Thus, if a creditor appoints his debtor,
Muted.
the debt is discharged by operation of law because the executor cannot have an action against himself.
Okay, renunciation, number 3, it says, under criminal law, complete and voluntary abandonment of criminal purpose, sometimes coupled with an attempt to thwart the activity's success before a crime is committed. Renunciation can be an affirmative defense to attempt, conspiracy, and the like. Model Penal Code, Section 5.01, subparent 4, also termed withdrawal. Abandonment also.
You want to hear my definition of renunciation?
Yes, go ahead.
Sort of blocks lot forth. The act by which a person abandons a right acquired without transferring it to another. Just thought that sounds like a lot of trust stuff in there. What does that mean exactly? The act by which a person abandons a right acquired without transferring it to another. Abandons a right acquired without transfer. Is that like an entitlement or something? Abandons a right acquired?
Yeah, that would be our right, title, or an interest, yeah. Which means withdrawal, right?
Without transferring it to another. So it's just given up. it goes into, if you abandon it, it can cease to exist or something without transferring it. What do they mean by that? The act by which a person abandons a right acquired without transferring it to another. Yeah, like a renunciation, right, of an entitlement. That's under the negotiable instruments law, the unilateral act of the holder, usually without consideration, whereby he expresses the intention of abandoning his rights on the instrument or against one or more parties thereto. That doesn't sound like what we want to do, though. In that context.
Christian, I think discharge comes closest to what you want.
Yeah, I think so too.
Unmuted.
Of charge, hence to release, liberate, annul, unburden, disencumber.
Here's something, the word renewal. And again, this is in the Encyclopedia of Banking and Finance. It says, when a bank extends a loan by permitting a borrower to substitute a new note for a maturing note, the new note is called a renewal and in the legal sense constitutes a novation if the old note is surrendered. The renewal of a loan should always entail the cancellation of the maturing note and the making of a new one, and bookkeeping records should show such cancellation and renewal.
What's the definition of withdrawal in the banking book?
It refers to something else. Let me go there again. It says checking account deposits, parentheses, individual partnership and corporation accounts as demand deposits are subject to withdrawal by the depositor at any time without notice, by check or in cash. Negotiable order of withdrawal, parentheses, NOW, accounts serve transactional purposes without the requirement of prior notice of withdrawal, as do arrangements for automatic transfers from saving balances. It gets into passbook savings and time deposits and things like that. Demand deposit. These substitutions in collateral. Not sure that that's where we want to go.
So if we have a general deposit account, deposited these charges into the court, expect us to be depositing them into there under general deposit. And corpus juris secundum would said what a general account was subject to the check of the depositor. Write a check against the charge, would that not discharge it and act as a withdrawal?
Sounds like it.
Maybe that's what we just have to do. We just have to write a check against our general deposit. The check would be a withdrawal, which would act as a discharge, and then do a special deposit, redepositing it onto the private side. So we'd have to write a negotiable instrument on the charge itself. Now, how could we make that look different?
Can't you just state that that's what you're doing? I mean, does it have to be something that you're calling a particular?
Muted.
If you call your general deposit a general deposit, and then you're pulling it out as a special deposit, or you're pulling it out and making it a special deposit on the other side, why would you have to do anything else?
Okay, let's look at a check. A check is nothing than a pay-to order, so it's an order. So if we do a withdrawal order, would that act as the discharge? Because that would be the check.
I've just found out that a check
Unmuted.
is called a demand account.
Yeah, right. It's subject to the demand of the depositor by check.
The maker writes the various details, including the money amount, the date, and a payee on the check, and signs it, ordering their bank to pay this person or company the amount of money stated. Originally, there was no bank involved.
Maybe we should put in a withdrawal and discharge order.
Here's another one. I'm looking at payable to order in UCC 3110. And it says an instrument is payable to order when by its terms it is payable to the order or assigns of any person therein specified with reasonable certainty, or to him or his order, or when it is conspicuously designed on its face as exchange, or the like, and names a payee. So maybe that word exchange can be used somewhere.
Well, that would be a bill of exchange then.
Yeah.
Non-negotiable?
Well, this is under negotiable instruments law.
Well, there is no such thing as a non-negotiable negotiation. You know, if you're negotiating, then it's going to be a negotiable instrument, even though you call it non-negotiable.
Kristen?
Jacob, go ahead.
That's Jacob. How you doing?
Good.
In Title 12, Chapter 17, Section 1841,
right.
You know, it defines what a bank is.
Muted.
And it says an insured bank, as defined in Section 3H of the Federal Deposit Insurance Act, B, an institution organized under the laws of the United States, any state of the United States, the District of Columbia, Territory of U.S., Puerto Rico, Guam, ASVI, both. It says except demand deposits or deposits that the depositor may withdraw by check or similar means for payment to third parties or others. And number two is engaged in
withdraw by check.
Huh? Yes.
Withdraw by check.
Yeah. Now you know that this is not positive law, so it would be best to go back to the statutes at large and actually see what they're trying to cover up with, with this.
Yeah, or the statute's annotated.
Yes. Now here's a deeper meaning here. Bank means a national bank, including a federal branch as defined in Part 28 of this chapter with federally insured deposits. General. This part applies to all banks except as provided in paragraphs 2 and 3.
Yeah, that keyword general. Key on that. That puts it right in the public.
Listen to what they get to, because this is the key. Federal branches and agencies. This part applies to all insured federal branches and is any federal branch that is uninsured that results from an acquisition described in Section 5A of the International Banking Act 1978. That's 12 U.S.C. 3103A8. C33, certain special purpose banks. This part does not apply to special purpose banks that do not perform commercial and retail banking services by granting credit to the public in the ordinary course of business, other than as incident to their specialized operations. These banks include bankers' banks, as defined in 12 U.S.C. 24, the 7th, and banks that engage only in one or more of the following activities: providing cash management controlled disbursement services or serving as correspondent banks, trust companies, or clearing agents. It goes on to define trust companies. Bank means a national bank, including a federal branch as defined in Part 28 of this chapter, with federally insured deposits, accepted and provided.
The DTC, Depository Trust Company.
This is the inner works of the DTC. Here it goes. It says general. This part applies to all banks except as provided in 2 and 3. So here it goes. We move into 12 CFR Part 1, where it now defines investment securities. And it says, source 61 FR 63-982, December 2nd, 1996, unless otherwise noted, subsection 1.1, authority, purpose, and scope. Authority. This part is issued pursuant to 12 U.S.C. 1. B, purpose. This part prescribes standards under which national banks may purchase, sell, deal in, underwrite, and hold securities, consistent with the authority contained in 12 U.S.C. 24-7, and safe and sound banking practices. This is the scope. The standards set forth in this part apply to national banks, District of Columbia banks, and federal branches of foreign banks. State banks that are members of the Federal Reserve System are subject to the same limitations and conditions that apply to national banks in connection with purchasing, selling, dealing in, and underwriting securities and stock. In addition to activities authorized under this part, foreign branches of national banks are authorized to conduct international activities and invest in securities. 93A, authority to prescribe rules and regulations. Anyways, I wanted to kind of just interject this because you guys were busy looking at banks and stuff, but, you know, if you look at history and you look at how many people were hoodwinked for the last 20 years under debtor-creditor, it's very possible everybody could be hoodwinked right now. And so you have to be very careful in discerning what actually is really taking place, and you must have proof. So it's possible with the research I'm doing right now that we don't even have a loan. And everybody's going after the bank to get this loan money back, when in actuality we have a security that's being held by the government. We could be going down the wrong hole, so we have to be more thorough to, I guess, discard any possibility that we're not being hoodwinked and being led astray.
I think that the security is really nothing more than the debtor-creditor trap also, as well as the debt that you supposedly have. The fact is, I made a special deposit. I just never really expressed it as a trust, so I don't have a special deposit until I claim it as one. So we need to go back and treat these things that we did in the past under debtor-creditor, no matter whether it's securities or notes or whatever they are, treat them as no withdrawing them from the general deposit, no matter whether a negotiable instrument or a security. They were they're still considered, you know, general deposits.
Even though we don't have a loan?
No, I don't really care if we have a loan or not.
No, I know. I'm just saying, even if we don't have a loan?
Yeah, because if I made payments on a fictitious loan, can I get that back? It makes no difference whether I got a fictitious loan or I do have a loan or I don't have a loan. It's the fact I made a payment.
If you go in and bring the cause of action as a plaintiff, then you have to prove that you have a loan, right?
Well, if I'm going to say I made a loan, but I could say that there was fraud because this was a special deposit. This wasn't any loan. I wouldn't claim a loan. I would be duped into making payments on a fraudulent loan. Here it was a special deposit under trust. But instead of playing their game and argue their facts, no, I'm gonna claim trust, prove trust, and then come at them for a breach of trust. Now, if I keep on playing my game and don't get trapped up into demurring and traversing into the air,
Unmuted.
then I'm going to stay on the private side.
And here's something to support what you've been saying about special deposits in the Encyclopedia of Banking. It says, special deposits consist of property other than money, for example, bonds, stocks, notes, life insurance policies, and other valuable papers, jewelry, silverware, plate, etc. So the notes are special deposits.
There's another term under withdrawal that I just come across. It's called
Muted.
Removal?
Yeah.
I want to add in another word there too.
Go ahead.
I want to put some context on this because I was just thinking about what we do on a computer. If anybody knows about like the DHCP thing, essentially when you start up your computer, it goes to a server and it asks it essentially for a release. And then it gives you, and that's how you get your IP address. And sometimes that messes up. And you have to, there's a function where you do a release and then it clears it out essentially, and then you do a renewal. And I was just thinking, they use a lot of terms like, I noticed commands and functions like this in computer terminology. And that kind of ties back into I just see this as a two-part process. You do a release, and then I'm thinking about what you guys are all saying, and everything's in accrual anyway, so we got to put it back in. So we're really just recording the act of that getting back control aspect of the account. Does that make any sense?
Well,
yeah, withdrawal would give you control again.
And you should check out the definition on release.
Well, that's what I said earlier on the show. That's what I'm into right now, release.
Okay.
I've been studying release for the last, week or so.
Yeah, it's heavy. It's got the withdrawal and their discharge of a debt. It's everything: relinquishment, concession, or giving up of a right, claim, or privilege by the person in whom it exists or who it accrues to, the person against whom it might have been demanded or enforced. In this sense, it is a contract. It must be supported by a lawful and valuable consideration. So that's, I guess, colorable. A discharge of debt by the act of a party. An express, and then actually, okay, as distinguished from an extinguishment, which is a discharge by operation of law, and in distinguishing release from the seat.
Wait a minute, you got discharge, withdrawal, and all that saying that right and where?
Black's Law 4th on page 1453. I'll read it again. In this sense, it is this is release.
It's release?
This is release, yeah. A discharge, and it's a big one. It's it's another almost a page definition. A discharge of debt by act of party as distinguished from an extinguishment. That's as distinguished from an extinguishment, which is a discharge by operation of law. And in distinguishing release from receipt is evidence that an obligation has been discharged. A release is itself a discharge of it.
So it also contains the word withdrawal in there?
Did I see that? No, but there's more here. An express release is one directly made in terms by deed or other sustainable means. Check this out. An implied release is one which arises from acts of the creditor or owner without any express agreement. A release by operation of law, that sounds interesting, is one which, though not expressly made the means and consequence of some act of the releaser, so it sounds like there's presumptions all over the place. For instance, when one of several joint obligers is expressly released, the others are also released by operation of law. So it just goes on. There's just a lot of stuff. I also think in terms of the dynamic of if you did release the funds, since it's all accrual funds, it's got to be basically just written. It's only for the purpose of renewing it again, right? Because we want to basically establish a proper trust.
Yeah, we don't want to renew it again. We want to redeposit it as a special deposit under trust.
But before we do that, we have to do the release. I'm thinking, because this just fits. This is almost what the server's doing.
Yeah, or something. They do the withdrawal or release simultaneously with the redeposit.
Yeah, a release for the purpose of a renewal.
Yeah, and the renewal would be redeposit under special deposit per trust. We probably have to make that distinguish from, hey, we just don't want to withdraw and then redeposit it again. They'll be putting it back under a general deposit again.
Or we can't just withdraw and expect like some big bank account full of money because there is none.
Yeah, well, what we put in was debt, and we'll get debt back out.
We're just looking for the right of authentication or signatory signership, basically, to sign off on.
Just like Jacob said, withdrawn by check. And Corpus Juris Secundum was saying it was subject to the check of the depositor. So a general deposit under a debtor-credit relationship, the credit deposit is subject to the check of the depositor, or it's withdrawn by check.
That kind of gets back to that story of that guy when they were experimenting with the signing without prejudice, and he signed a check and mailed it for payment on a Visa, and they put what do you call it? I don't know a lot about checks and stuff, but what do you call it? You don't have funds in the account, NSF. Okay, yeah. Then because he had some kind of special cover. Now he requested and got the extension of the credit on the account, whatever that's called again. I keep forgetting that one too. But he just told them, he said, well, release that or remove that from my account. And because I guess he had that service. But they never got on to him about the check at all. And eventually they had to fall back on, we misplaced the check. They wouldn't, he said, well, I sent that and they've accepted it and it's made payment towards my credit card. Yeah. He said something to that effect. So
well,
he was close.
Order of withdrawal and a discharge, that's probably going to be the check, and that would probably contain two of the key words to release it.
Christian?
Yeah.
Under removal, it says the number one definition is the transfer or moving of a person or thing from one location, position, or residence to another. Number two, the transfer of an action from state to federal court.
Mm-hmm.
Well, you're removing, you could remove the one, what would it be, account to another place. And that's, in that sense, you're transferring it.
Yeah, remove by withdrawal and discharge.
Yes.
It says transfer. Yeah. Transfer of a person or thing.
Well, if we probably put maybe a couple extra switches in there like words, that might serve the effect. But I think the order for withdrawal, that is the check itself. It's a draft. Because when I give an order, whether it be a pay to order or order to withdraw.
Hey, Christian.
Yeah, go ahead, Chris.
Here's another thought. You know, when you go look up, 1099A, they use abandonment and acquisition.
That's withdrawal, abandonment.
Yep, that's what I'm saying. I'm reading it right here, right now, and it's talking about withdrawal.
You know, that's something we never thought about. 1099s are withdrawing your general deposits that you made and returning it back to the principal.
That's right.
Back into the private.
There was a guy, one of the accountants, he came up with this huge insight, or at least he felt that, and it certainly seemed that from the way he was talking about it. And he said why it doesn't work a lot of times is because you have to make some records to show that you gave it to them and it makes them the nominee, and now they have that record, and then I think you send all this stuff to IRS to make the records of it. Then you also send them.
Makes the claims, got to prove it. So if you're claiming you want to withdraw, you got to prove that you made it.
Well, not only that, but I think it rebuts the presumption of gifting. And I like, because everything's some kind of rebuttal or some kind of presumption. Because that's the way they got everything hidden, right? We can't, that's a hidden presumption, I think. And then you also have to, he said ask them, and I told him you don't have to ask them, just make it a self-authenticating contract. Basically send them a letter saying that you're going to be following up with a, whatever the other one is, I guess the acquisition. So it's like a two-step process again. Mm-hmm. And I haven't followed up with them because I kind of left that. But actually, I noticed with all of our stuff that we're doing it the old way, everybody was getting no response. And then when they called them up, they got a frivolous charge, right? And this was before we realized this extra step here. So we were all waiting to get this, and then we're going to do it on the next one. But I'm thinking what happens is they got it because every time they call up, they go, oh, yeah, here it is, bang, frivolous charge. So it's like they're waiting for you to correct what we're doing. That's what I'm starting to think now.
Or possibly they left out a step because they didn't claim it first before they claim that they had it.
Exactly, yeah. So they know it's improper, it's not complete.
Yes, right. But that's the first thing we got to do, put it on UCC1 and a county claiming it.
Or that we gave it.
Well, yeah, the claim, yeah. He who makes the claim's got to prove the claim. If you're claiming the right, you have a right to withdraw it. You better have claimed it first as yours to begin with.
Is there some kind of way to make a record that we also, not that we have a claim to it, but some record that we in fact did give it?
Well, no. Once you do the UCC1 in a county with the case, say, claiming the case, now you could do an order to withdraw it.
Okay. I'm just thinking, like, in this similar vein, before we make the claim, is there something we could do to show some kind of record that we gave it to them in the first place? Is there anything like that? I'm just larking here.
I'm proving up the signature that I put on there the first time, so that's my claim. I just
how does
my signature.
Christian, how does a remission grab you?
I don't know, what's the definition?
At common law, the act by which a forfeiture or penalty is forgiven.
Somehow we're going to get tied into discharge, because I think they're going to look at it as discharge, you know, UCC that comports with that, and all the other stuff in the public, discharge of public debts, bankruptcy, and all that stuff. That all ties in together. So somehow we got to dovetail it into withdrawal being discharge, or maybe a few other words that reinforces the whole meaning.
Yeah, that was at common law. Then in civil law, we've got a release of a debt. It is conventional when it is expressly granted to the debtor by a creditor having a capacity to alienate or tacit, when the creditor voluntarily surrenders to his debtor the original title under private signature constituting the obligation.
Yeah, that kind of sounds... And that's remission?
That's remission, yeah. It says forgiveness or condonation of an offence or injury.
And mine says a release of a debt.
I don't like forgiveness, because forgiveness is only for the real man, not for the fiction.
Got ya. Yeah.
But some of the other words that they're using in there sounds good.
Christian?
Yeah, Jacob, go ahead.
If we were going to have express a trust, and it wasn't a loan that was made, but our personal note was converted into a security through a banking license, would it still be a special deposit? What party would the special deposit go to in that case?
To whoever the trustee would be that I would appoint, which would probably going to be the bank.
Because I think they're just a front operation. They're just a converter. Because there's no bank. They're only a servicing agent.
Well, originally they held themselves out to be a bank, and they're holding themselves out to be the lender.
Yeah, but I mean, right now, I've been searching Fannie Mae, and apparently right now, today, they own 60% of all loans already.
Well, that's great. You know.
And the banks are
they got my general deposit then.
The bank got your general deposit?
Yeah, I just need to withdraw it now and turn it into a special deposit and redeposit it.
But Christian, if I can get back to that part about using the 1099 model, where the mistake we were making was trying to acquire it without clarifying that it wasn't gifted, by creating the previous record showing that in fact we gave it.
Right.
Is there? You would know if there is something that before we make the claim, can we do some kind of record of saying we're doing something of it, we're trusting it, as opposed to just giving it to them, and then making the claim?
Well, trusting is giving. It's gifting. When I give my name, I would give it in trust. But the trouble is, we just never expressed it to be a trust, so there is no trust. It's always debtor creditor, because we're making a general deposit. I can see that plain as day. That's been our biggest mistake. Everything we're doing generally. We're doing nothing specifically, nothing specially. We need special deposits. We need to have under certain special circumstances. It's got to be exigent circumstances, which has got to be done first and prior above everything else. And the common way of doing it under general deposit is alleviated or bypassed, circumvented.
Does that get back to that concept of declaration of intent? Clarify that?
that might help you reestablish it being under trust.
And then claiming it.
That's exigent circumstances, yes. Special circumstances.
I'm just sort of going off that 1099 thing that I barely understand either, but.
Yeah, but I think they're right. That just kind of reveal the fact probably that nobody's claimed them properly as theirs first to be able to do a 1099 and order it back to themselves. And the IRS knows that.
Yeah, he was picking out all this specific terminology, like, he said something about they become a nominee, which means, and then looked that word up, and he was looking for the angle, right, because he's a bit of a...
Here's the key. The key is that under a general deposit, which everything is because we don't express it to be a trust, under a general deposit, that transfers title from you to the bank. And now you no longer own it. Now you have an equitable interest and a choose in action, but you don't own the legal title any longer. And that gives the bank the ability to claim it as theirs because you transferred title to them. Now they own it. Now they can loan it back to you.
Wow.
Christian?
Yeah.
Under this 12 U.S. Chapter 5, subsection 1, it says receipt of United States or bank notes as collateral. No national banking association shall hereafter offer or receive United States notes or national bank notes as security or as collateral security for any loan of money, or for consideration agree to withhold the same from use, or offer to receive the custody or promise of custody of such notes as security or as collateral security or consideration for any loan of money. The quote, 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 the officer or officers of any association who shall make any such loan shall be liable for a further sum equal to 1/4 of the money loaned, and any fine or penalty incurred by a violation of this section shall be recovered for the benefit of the party bringing such suit. So it goes on to say that when a loan is intentionally made by an insured bank, one tends to believe they were loaned the bank's money. Yet in reality, the loan is funded by the promissory note, and the term is check draft. Remember what we just said about return the check? What was it?
Withdrawn by check.
Withdrawn by check. Let me write that down. Withdrawn by check. Okay, so the bank has rights in depositing promissory notes.
Yes,
as
it's just what I changed because you transferred title to the bank.
Which title again?
The legal title.
Okay.
The possessory title, the 9/10 title.
Thank you.
But you still retain the 1/10 beneficial interest title. That gives you the choose in action because you got an equitable claim. That's your beneficial title in equity. You got an interest. You got a right because they owe you. And you don't have any substance, so to speak, other than your right because you gave it to them and they owe it back to you. And that's an equitable claim. That's the only way you're going to be able to get. You can't get it at law because at law can't enforce that claim. Only equity can enforce that claim, which is a specific performance. They didn't give it back to you. That was a specific performance. They didn't give it back to you. And that gives you the choose in action under an equitable claim. They've got title. They're claiming the title. They got the title. You gave it to them. And now they can loan it to you again.
So that somehow has to be established, and then you put it in your claim.
Well, establish the fact that you signed the note, and you as the note in that quote I keep on quoting all the time out of Book 10, which says that the issuer of the instrument always retains ownership in the document or the note, and you could always ask for it back because it's always yours. And the proof is you signed it. Who's the signer on it? Well, that's mine. I want it back. Except maybe you've never put it on a UCC-1 in accounting and claimed it, so therefore you can't get any public notice, and the public doesn't know that you own it. So I had no right to claim it back or order it back or withdraw it or 1099 OID it.
Yeah. And sorry, I got to go over this because I'm still straightening my head on it. Legal title is the 9/10, that's the possessory, and the equitable title is the 1/10. And what's that corresponding term to possessory?
Beneficial or equitable interest.
So, well, the legal title and the equitable title, so it's still called equitable as well. With
Yeah,
the
beneficial interest and equitable interest, or equitable title and beneficial title, they're all synonymous terms. They're all the same thing.
Okay. Thanks.
Legal title is, possessory title is in the trustee, and that's the different title. That's the 9/10 title. But probably in order to ask for your title back, because you gave it to them, and give by definition was you voluntarily transferred it to them without compensation, then in order to claim that, you'd have to do a probably UCC-1 and a UCC or county, claiming that that's your note because the fact is you signed it. That's a material fact.
So the claim isn't a literal claim. You're just establishing that you are in fact just establishing that you gave something.
Yes,
in trust.
Which would be a public notice, a UCC-1 in a county, even though that I signed the note 5 years prior.
And that corrects the giving and makes it more into
doesn't correct the giving yet. It just puts a claim that it's mine, and now I can correct it from a general deposit to a special deposit by ordering it back. Do a withdrawal or withdrawal and a redeposit. Redepositing under a special deposit with specific instructions, specific purpose. And that would be exigent circumstances. That would be special. Exigent circumstances being private, which would be protective, really. It's a protective order. Well, they always ask, well, what's your grounds for your protective order? Well, exigent circumstances. Special deposit.
Directly. That would be a go directly to Chambers. Do not pass go. Do not collect $200. Just
yeah, it might be that simple.
You got to have your ducks laid out, though.
I like that definition of Black's Law. Exigent circumstances was a situation that demands unusual or immediate action and may, and remember may means must on legal speak, and must allow people to circumvent usual procedures. And what would usual procedures be? General deposit,
Well, can you say the word again?
Which one?
The one you just defined.
Oh, that was exigent circumstances.
Can you spell that?
It's two words, E-X-I-G-E-N-T. Circumstances.
Okay.
If you look under circumstances, you'll have to look under subheading of exigent circumstances. But it says, the situation that demands unusual or immediate action and may allow people to circumvent usual procedures. If you look up may, you'll find out that may means must. So may means must allow people to circumvent usual procedures. And the usual procedures is everything that's not treated specially is general, and it's a general deposit into general funds. And it's not a trust. And that gives lead to the debtor-creditor, or gives rise to the debtor-creditor relationship.
Christian, I would just add to that if I could. So may means must, but of course the corollary is must means may. So, but it is in fact saying that it is possible.
Yes.
Here's a good one for you. Release by way of trust.
Yeah, there is no adequate remedy except in chancery under equity. And equity is where trust operates exclusively.
So you can actually have one line that says release by way of trust, exigent, how do you say that, exigent circumstances? By, I can't even say the word. Release by way of trust, by way of exigent circumstances.
Yeah, something like that, yeah.
Yeah, yes, that kind of has a nice completeness to it. By way.
Yeah, exigent circumstances are special circumstances, are uniqueness. And notice it said people. It didn't say persons there. It's one of the few places that I've ever saw that it said people. It must allow people to circumvent usual procedures. First time recognizing the real flesh and blood men and women.
That's significant.
Yeah. It's kind of nice just to be able to go through these definitions tonight, you know it? I've really been appreciating it.
How do we spell that word, Christian, the exigent?
That's E-X-I-G-E-N-T.
I-G-E-N-T. And then I was thinking from what Chris said, release by way of trust for exigente for equity term.
Yeah.
You said look under circumstance was what you started with, and then you look at a subsection?
Yes, circumstance first, and then find exigent.
Okay, circumstance.
I think it might take you to special circumstances, and then when you go to special, it tells you maybe to look up under exigent circumstances. I forget. You might, well, try it and see what happens. You might have to go to exigent circumstances directly.
I think you're probably right, because circumstances doesn't have any following after it.
Yeah, look up special then, under circumstances.
Well, it has extraordinary circumstances.
Does it list special or exigent?
No, it didn't do that, but let me go look and see if I can find it under exigent.
Look for special then.
Right. Special, here we are.
Christian?
Yeah, Carlos.
When you get a chance, do me a favor, go to your Skype. I left you a little message.
Okay. That has to be after the show.
Yeah, no biggie. I'm awake all night anyway. I'll keep my computer on. Thank you. Everything that you were saying, it was a mirror image of the land trust, we end up in the same place, a trust.
Christian?
Yeah.
The concept here is to ask for the withdrawal of the documents?
Right. Mm-hmm. Well, not to ask, order.
Order the withdrawal of documents?
Yes, not the documents, but the general deposit.
Oh, the general deposit.
Which would be the deposit, or the document, yes.
But the general deposit was the promissory note?
Yes, or the case, or anything you put your signature to. Can you imagine everything that you've signed is in your individual master file?
That can get embarrassing, you know.
That all basically points back to the birth certificate. Is that right?
Well, I don't know.
Like joinder.
Certificate is in the master file also, along with the Social Security account in the master file. You know that I've put signatures on all those documents, so they have to be in the master file. It might be that that's just a stock certificate of the United States until I express it to be a trust deposit.
I remember Winston saying something like it kind of tied with what you were saying about the boundary. It's simply a boundary that separates you from another party because you always...
That's just one method of identifying the person, the boundary. Name is another one, and public versus private is another one. And public versus private is where you're going to hold your estate, and that would probably be your identity. So identity is the essential thing, not the name, not the boundary.
Well, that's the corresponding public and private again?
Yes. It's one method of identifying the real identity of the thing.
It's the identity versus boundary?
No, identity is the essential thing, or the identity is the identification of the essential thing. It is the essential thing.
Somebody told me that...
Name is just one method of identifying the identity of the thing. There are others, and those others are name, boundary, public and private.
Okay.
Yeah, it includes both, right?
No, there were three. Gave name. Name was one, two was public and private, and three was boundary.
No, but I mean, it includes both the trust or the account or whatever it is, and the physical.
That's the identity of the state, the thing.
Well, I've heard this guy who does research on the person, that the person is a combination of that mask as well as the mask holder.
Yeah, that's what we're talking about.
Yeah.
Christian?
Yeah.
In a format about withdrawing everything and ordering that to be done, I mean, could another style be applied, such as you're going to, you want to pay the note, and so you come up with like like the opposite way where you would say you would require documentation that the holder is in fact the holder in due course.
Can't pay the note.
Huh?
Or you really can't pay the note.
Well, that's the point.
Okay, you know what led me from that word, exigent circumstances led me to special circumstances, which led me to warrants. And listen to this. In contract to engage or promise that a certain fact or state of facts in relation to a subject matter is or shall be as it is represented to be, in conveyance to assure the title to a property sold by an express covenant to the effects in a deed of conveyance, to stipulate by an express covenant that the titles of the guarantee shall be good and his possessions undisturbed.
An express covenant is an express trust. Bingo!
There you go. And I knew that warrant had something to do with all this because it was just brushing elbows, so I just wanted to...
Here's another one. Warrant is order.
Yeah, it says an order by which the drawer authorizes a person to pay in a particular sum of money.
Order the withdrawal. Order the withdrawal and discharge. That's your warrant. That's your check. Now, if we can just make it colorable enough with enough switches in there that they'll recognize it, so we can make the circuit and pay the charge, so to speak, on the colorable side, but then withdraw it and put it in a special deposit in trust.
Why not just issue a warrant? Because it appears that this could be what catches their colorable attention.
Well, I don't know. Is there any warrants recognized in their realm that we can write?
Well, I'm sure. I've got probably 1,000 on my computer. Let's see. Let me just read on.
Or would they be more apt to look at it as a check or a bill of exchange, or maybe just an order to withdraw, order to withdraw discharge?
Let me just read off a couple of them that are pertinent to what we're talking about. They've got, let's see, they've got distress warrants, and they've got stock warrants, warrant creditor, warrants of arrest, we don't need that, landlord warrants, land warrant, outstanding warrant, warrants of commitment, warrant officers, warrant of mercantility, of warranty, I guess it would be, warrant to be sued and defend, and then warrants upon indictment or information. So they've got quite a few different ways it can be used. So it doesn't just mean a person being arrested.
Yeah, actually a warrant is just an order to the sheriff to go pick him up.
Christian, have you ever heard of the concept of arrest means to place a lien?
Yes, right. That's what I've been saying all along. Well, foreclosure is an arrest.
So if we make a warrant, then we're obligated to follow it up with some kind of arrest?
All these things are the same thing, really. Just a different time frame. It's called something different. An affidavit starts out as an affidavit, but it ends up after a process, it turns into a bond, turns into a perfected lien.
Mm-hmm.
Well, here's something interesting. I'm on to something. Warrants for bankers. I got to find out what this is about.
Christian, isn't the special deposit a trust deposit?
Yes. If it's a specific purpose, could be a bailor-bailee relationship agency.
But I mean, is the idea to get the bank to accept a receipt for a trust deposit as the special deposit, so you have a trust receipt that they've received it and it's in their possession, so that you can now make an order? You now have proof that they have it in their hand?
Yeah, but all I have to do is give them notice of the special instruction. That is the agreement. That is the contract.
But what about if you do it in two parts? What if you first get the trust deposit into the bank, then you give them the order once they have it, and you have a receipt for it that they have it, and then order it?
Give the order to what?
To use the special deposit to extinguish the obligation.
Yeah, that's basically what we've been talking about all along.
No.
Well,
I'm talking about doing it in two parts.
We're talking about doing a 1, claiming it, and doing a 3 for establishing the trust. And then we're talking about doing a second set, a 1 and a 3 again, to maybe make a payment.
And I'm talking about after that.
The same thing what I just said.
No, I'm talking about depositing it into the bank. Once you've done all that and you actually have that, now to deposit it into the bank.
As a special trust deposit, right?
Yes, in safekeeping.
That's what I did, deposited it into the bank.
Here you go, CW. Warrants are securities without interest and dividends attached, granting the warrant owner the rights to buy. And then it's going to go, I have to open it up, but that was the first comment that it had.
Entitlement order.
Okay, here's the full, warrants are securities without interest and dividends attached, granting the warrant owner the rights to buy, call warrants, or sell put warrants. A certain
8-507. 8-507 on UCC.
Okay.
Entitlement order.
Entitlement order 8-503?
507. 507.
Okay. A call warrant has secured the purchase. That a return can be obtained in the market price of the underlying assets exceeding the set strike price. So it's got a little bit of the language we're looking at and putting something together here.
Yeah, as long as we can keep it colorable, maybe under securities or Article 3 or Article 8 and 9, it would probably fly.
Yeah.
It would be colorable enough.
That's pretty cool.
Christian?
Yeah.
Let's say for example, somebody owes $100,000 on a mortgage to Bank of America, and they go ahead and they claim the note, and then they transfer the note on a 1-3, and now they have Now you go to Bank of America and you open up a Bank of America trust account, and now you deposit the trust. You put the trust deposit or the special deposit. You just call it a trust deposit, so they don't know it's a special deposit when you're putting it in there. And now you ask them to put it into safekeeping for you under the trust account. So now Bank of America has the indenture or the special deposit. They have it in their possession, and so then you just order for them to take.
How did they get it in their possession? When did you do a delivery?
Oh, I just opened up a trust account and put it in.
Well, what in?
The special deposit. I put the special deposit in to open the account and have it held in safekeeping.
Of what? Where's the note?
Of the trust res. It's just a note. The special deposit is basically just another promissory note.
Well, where's the note? When did you give them delivery of the note?
I went down there and opened up an account.
Did you have the note and you actually gave it to them? How did you?
Just gave it to them for safekeeping in a trust account. So now they have the note.
No, you're missing my point. I'd like to know how you got the note.
I made one up. Same way I did it the first time. Same way I just signed my name on a piece of paper, made it into a note.
But that's another note. That's not the same one we're talking about on a mortgage.
Well, then say it's the same note that you did a 1 and a 3 on.
How can it be? That'd be a second note. That'd be a forgery.
That's right.
Well, then it would just be the receipt.
Well, we're not talking about receipt. We're talking about the note. In order to open up a second trust with another bank, you'd have to have actual possession of the note and then deposit the note.
It's not another bank. It's the same bank.
Well, why go and do it again? You already did it the first time. Just claim trust.
Because you don't have an account that you can make deposits. So you open up a trust account where you can make deposits.
Oh, yes, I do. Any deposit of any deposit, special or otherwise, is an account. Don't have to have an account. When I make a deposit, that becomes the account.
Okay, so you've deposited the promissory note into a trust account at the bank?
The first deposit formed the account.
A trust account?
Well, it's not a trust account until I express it to be a trust account. It's a debtor-creditor relationship.
But by going in and opening up a trust account, isn't that expressing the trust?
Yes, it can be, but what is the res?
The res is going to be the trust corpus, whatever you make it. In this case, it would be the note.
Yeah, but the original note is, I don't know where. All I know is that I gave the note to the escrow company, and the escrow company gave it to the bank. That's a proof of trail. Now I can change that around to make that the special deposit by expressing it to be trust. Why don't I go ahead and make another account? I already got one.
No. Well, so you can merge the two.
I don't need to create another account to merge the two.
Well, if I have the original promissory note is in an account with them, and I have the special deposit in another account with them, and I tell them just to use the one account to pay the other account, then it's merged.
But they're going to tell you they don't have it. And they're going to tell you there's no account because it was all done generally. They're going to tell you that.
But if I have proof from the trustee of the escrow closing that they do have the note, and I have proof or receipt that I deposited.
That doesn't prove that they've got the note. That proves at one time they had the note.
Okay.
But that's all that matters to me. If they had it one time, that means they were holding, and that was all I needed right there. I don't care what they did with that note after that, because now they're entitled to me because they don't have title to this note. I have title to it, and I also have the beneficial interest. I'm going to be making the claim under trust, not under debtor-creditor.
But you can't make a claim by opening up a trust account in the same bank, and you put the special deposit in their bank?
You mean a second time? A second trust? Second trust deposit?
An actual one that you have a receipt for.
You're going to make up another note, and you're going to give them another deposit or another trust.
Another note. It's going to be just the special. It's going to be the note as a special deposit.
The first note, or the second you're going to create.
The first note as a special deposit is the trust res.
Yeah, but you can't do that. Where is the note? You don't have the note.
if you claim the trust and you use the promissory notice, the trust res, and you transfer it to the trust that you open up at the bank.
When did you transfer it?
When did I transfer the special deposit?
Oh, yeah, or a special deposit, or when did you transfer the note?
Well, I transferred the note on the trustee for the escrow closing. Transferred the note at the closing of escrow, or shortly thereafter.
Yeah, the moment you signed the note at escrow closing, that day, the bank got the note.
Right, if not sooner.
Yeah.
Okay. So now I'm claiming trust, and I'm claiming the special deposit as the trust res, and now I'm transferring the special deposit to the bank.
No, it's already been transferred to the bank.
Not the special deposit hasn't.
Yes, it has.
I mean the trust res.
Yes, it has. The only thing you haven't done is you just haven't created the notices of a past transfer. And you've got no note to make a second transfer with any other substance to it.
So I can't use the notice as some kind of promissory note?
No. When did they actually receive trust res? That's what I keep coming back to.
Day of closing.
You can't create out of thin air a second deposit unless it's with a new instrument, which makes it another trust.
Well, why can't you make up another promissory note for an equal amount that they say you owe them?
Can't do that. That's a second note.
Because that's a two-party process, too?
No, it's not. It's one party. It was in the beginning. It was one signature, and anytime you want, it can be one signature.
No, it can't. Make a second note. It's going to be a second signature on a second instrument, second document. And since you don't know where the original note is for the first one.
No, I do. I do know
where
the original note is.
Well, who's got it?
Who's got it? Mortgage pooling indentures got it.
Oh, you think so?
Yeah, I know so.
Isn't it dependent on the bank's accepting it?
You know that it was transferred into that pool, but I'll guarantee you that pool does not have the note because it's been securitized and commingled with everything else, and nobody knows where that note's at because they had to destroy it. And that's why they can't produce these notes.
But you can follow the chain of assignment to who they say who has it.
Yes, but that doesn't prove that they got the note. It proves that they had the note at one time. But now it's been securitized. There's no proof.
But it does prove that they don't have the note to be coming against you.
Yeah, well, they've formed a pool where they've chopped all the notes up, put them in the pool, mixed them all up, and nobody can tell the difference whose note's whose. That's what securitization does. It homogenizes all the notes.
Is that why you can't find these things on the QSIP number individually on Fidelity?
Well, you can probably trace it into the pool, but once it's in the pool, there's no way of tracing it from there.
But you could prove, but you can't. You could certify that they don't have it.
Yes, because you can order it back, and when they can't produce it, but then I would get them in for a breach of trust because you ain't going to get them any other way. They're too slick for that. You're playing on their ballpark, using their tools, dancing to their song, and you think you're going to get a remedy? It says there's no adequate remedy at law in court at the public side. The only way you're going to get a remedy is an equity in trust. Quit trying to play this garbage debtor-creditor stuff, Jacob. They got it all over you. It's a fixed game. You can't win.
It's like going to the casinos, boy.
Yeah, the deck is stacked against you.
The fix is
I
in.
don't see.
I'm going to come in with a higher law form under trust and smash the hell out of them.
It just seems to me, you can smash them a lot better once you've got the goods on them.
Colorably, on the court side, yeah, I could win under litigation. I don't want to win in their court. I want to close the account down and zero it. Even if I won, they're still laughing. They still got to win. They got all the bonds and notes in the background and everything under it.
Would you still think that way if it wasn't on a one-on-one situation?
A one-on-one situation.
No. Would you still think the same way if it was not a one-on-one situation?
I don't know what you mean by one-on-one.
Well, let's say instead of one mortgage, you have 1,000.
They're all the same.
No, but think of how much time would it take?
Why don't we just come in and claim antitrust and bust the whole thing up? Why don't we just be trust busters?
Yeah. That's exactly what we should do.
How come you're not doing it, Jacob?
Well, you wouldn't know if I was or wasn't on a call, trust me.
Well, some of the questions you asked, it was like, I wonder where your thinking's at.
Well,
hey, Christian?
I've already seen myself, that once you have the goods on them, they're willing to negotiate quickly.
Yeah, why? Because you really don't have goods on them. Even if I got the house and I got treble damages, that wouldn't be enough because they got the note.
Yeah. Hey, Christian, I've got to go here in a second, but I wanted to read you something, and then can I read something to you that's the best that I found on warrants, and then you guys can continue after I get off the call?
Yeah, go ahead.
Yeah, this is under finance. It says a warrant. What is it? An order drawn by a payor directing its treasurer to pay a specified amount to the person named or to the bearer. It may be payable upon demand, in which case it usually circulates in the same way as a bank check, or it may be payable only out of a certain revenue when and if received, in which case it does not circulate as freely. Number two, a financial instrument that gives the holder the right but not the obligations to purchase a specified amount of assets at a specified price during a specified period of time. A warrant may give its holder the rights to buy shares in stocks, bonds, currencies, and commodities. The major difference between warrants and options is that the price of warrants are usually published with lists of prices for the underlying assets.
What was the word that you looked up?
Warrant.
Warrant.
So it gave to me what it gave me is that there is a command, there is an order that when you issue a warrant, even though they're talking about stocks and bonds here, you still have the abilities on a trust is to put forth a warrant, an order, and maybe we could draft it with a release by way of trust language, and that extinguish circumstance information, and have that as part of our language on these orders.
Called a put and call. So a call would be a withdrawal.
Put and call. Yeah. Okay, well, I'll let you guys get back to it. I just wanted to interject and just say that one part. I've been waiting for about 20 minutes to share that with you. And you guys have a good evening, okay?
Okay. Night.
Night.
Shane, you got any closing thing on there?
Oh, no, I'm with you, Christian. I think something elegant and simple, but I think it takes a lot of understanding. If by definition, if we're stumbling and guessing, that's part of the thing that doesn't make us stand properly. I guess that's kind of self-logic there, but this is part of the, if we're guessing by definition, we're not completely on it, are we?
Mm-hmm.
And that's how they're going to push us.
Yeah. JC, you still on? You got anything to add? Or Pete? Pete or JC, you got any closing comments? Or Eric? How about Eric? Is Eric on?
Hey, Christian, I was talking there, sorry, and I forgot to press the microphone on.
Okay, we can hear you now.
Yeah, it's 10 to 7 here in the morning. I've been up all night, so anyway, I remember in the days when you used to say you'd save antitrust till, the last kind of thing, but now you're saying, well, you mentioned it as if that's the way to go directly. What do you think?
On something big, yeah, possibly for an enforcement, yeah. Especially on a class thing.
Sorry?
Especially on a class action thing.
Class action inequity? I mean, has it been done?
I'm sure it has, yeah, under different things. Under the Sherman Act, yeah.
Okay. Yeah, it was just that really that just struck me, the way you kind of expressed yourself there about the antitrust. I was just thinking, wow, you used to always save that till last, but I see what you're coming from now. See where you're coming from now with that. Excellent. Thanks very much.
Okay.
Hey, Chris, JC.
Yeah, JC, go ahead.
Yeah, I'm off my headset, so I don't know how this microphone is, but no, it's good. We'll digest this and we'll talk tomorrow.
All right. Okay.
Document prep.
Anybody else got last closing comments or something?
Christian?
Yeah, go ahead, Jacob.
Did you hear about that case where the lady just got $1.5 million for
the mortgage?
Compensatory damages.
For what?
Compensatory damages.
Yeah, but it was for being targeted as a, like a class action suit thing. But it was just one person. But it was that her knowledge was targeted because she was ignorant and she was drawn into the thing. I'll get the case for tomorrow. I just thought you might have heard of that one because that was the thing I was thinking, that kind of like for the class action suit, you've got all these, one people group, let's say Mexicans as an example, they've got targeted and, there's, hundreds if not millions of them that are out of their home.
Well, even that Tennessee case where they were coming up with all the fees that were not paid because they've sidestepped all the recordings. And all the counties were suing Mears. And
yeah. Right. The tax recording, the state recordings, you mean?
Right, correct.
Okay, I remember that one, right. Okay, that's a good one.
No.
Christian?
Yeah, Carlos, go ahead.
Yes, this is Claudio.
Okay, go ahead.
What do you think is going to happen to MERS?
Well, I think until somebody goes out and brings some damages and stuff against them, they're probably going to still be in existence, but in the background, really trying to control everything as usual. They got 63 million, was it 40 million or 60 million mortgages under their belt?
Yeah, 60 million.
Controlling. So I don't expect them to, bow out of the picture, but just remain in the picture underneath the surface, not seen.
Yeah.
Christian?
Yeah.
I have a substitution of trustees that's MERS right now, and they send it without they didn't even go to the county recorder to record it. And when they send it in an envelope with a fake certified mail sticker on it. You seen those?
Yeah, they do all those. They never record any of them. In fact, some of the other agencies are now copying what MERS has done, and MERS, I think, is operating in the background, giving them the assignments, and they're walking in with these fake fraudulent assignments again. Except they don't have MERS name on it. They got some Joe Blow's attorney firm on it.
Well, do they? Yeah, exactly. And they put the little, they put a fake certified number inside on the piece of paper, not on the outside, and it's just got a little green printed square, at the top of the middle of the letter, as if it was the actual certified receipt thing going along to the back side of the envelope. Right. And then it's got the red meter stamp, so it's not even postmarked. It's not signed. It's not notarized, It is signed by MERS, by the way. But it's not, so, are they required to record a substitution of trustee?
Was there, to prove their authority, I imagine they have to have a recorded assignment.
No, if they have a substitution of trustee, doesn't it have to be recorded?
I believe so, yeah. All the authorities and stuff have to be supposedly recorded.
But the real question you're asking is, do you need to know?
Well, yeah, it should be recorded so I can prove and so that we can know, but trouble is that's how they're doing it.
Yeah, but no, my question is that's a violation of due process, right? Or not?
Well, I know it's a fact that it's breaking laws in certain states because you can't have any real estate without a recording. But yet
they're fronting. You know what it is there's a law firm on the front of the notice, which is not signed, and then you turn it over and there's like one little paragraph, and then MERS is signing it on the back. Yeah, it's not notarized.
There's other cases where MERS is signing in the background. You didn't even know that they transferred it to somebody else. And Sally Mae, Debbie Lee shows up somewhere, and she's got a power of attorney to do an assignment to Deutsche Bank.
Okay, well, in this case, they just now, there was a negotiation going on with a loan mod, and then they said, well, we have to check with the investor, and then I'd asked, well, who's the investor? And they said, well, then they came back and actually told me Fannie Mae was the investor. So now Fannie Mae, for the first time in history, has been introduced that they're the owner of the note. And then they've got MERS, which is,
Prove it. Prove it.
Well, I have it in writing from the bank.
So they sent you a letter in writing that the notice is such and such.
Yep.
Now, you don't have quite a good enough record.
No, I'm not saying I'm relying on that. I'm just saying that was, that all of a sudden Fannie Mae is now the owner of the note. And they're coming and they've got MERS coming at you, acting as if the servicing agent is the creditor. And now, I think they accidentally slipped on the Fannie Mae thing. Making that known. But, you can go to the Fannie Mae lookup site, and anybody can put their loan number in there, and Fannie Mae owns 50% of the loans now. Do you know what's up with that?
Well, how did they get the loans? Where's the transfers for that? Because I'd like to know how it got into the securitization pool to begin with, let alone how it got transferred out of it.
I'll let you know next week. I'll have the results.
Something down the chain, it fails at the first break. And if it happened, on the third step, I don't care whether you're 60 steps ahead, the 60th step is still fraud. Because the third step was where the break came. Right. You can't transfer any right that you don't have.
You break one commandment, you break all of them.
Yeah, but you can only, it says in UCC that you can only transfer what right did you have. If you didn't have a right to begin with, what right did you transfer?
You cannot transfer something you don't have.
Right. If you don't have the right to transfer, if you don't have ownership to begin with, how can I transfer ownership to you? Can't do it.
Yes, Christian, going back about transferring the trustee, what Jake was talking about a minute ago, if you look back in the deed of trust in paragraph 24, it very clearly says the lender from time to time may replace the trustee, and the lender is not replacing none of those trustees in all the foreclosures we have down here in California.
Yeah, because there's no chain of assignment to prove that they transferred anything.
So we should bring that up. I had a friend of mine told me, you have to bring this up, and this is big, because it clearly states the lender, and only the lender can substitute. And who's doing the substitutions? Someone that doesn't have any interest in the party.
Yeah, but they'll get you to argue the note, the signature on the note, and get you to validate the note, or they'll come in with a reformation, or they'll even come in with copies and everything else to get you to argue that fact, you know. But it comes back down to really what they're doing is they're making a presentment under UCC 3-501, and you need to ask them to endorse the instrument and ask them for 2 forms of identification, because, or otherwise, that's your out, really, because now under 3-503, or is it 504? 504, you've got 2 exceptions to a dishonor. You got an exception to the presentment, and you got an exception to the dishonor because your right was to ask them for an endorsement. And if they don't endorse it, you're out of the picture. They can't foreclose on you.
Yes, and there's no dishonor in non-payment also. That's what it says on 501 in one of the articles.
Yeah, 501 is presentment. But under 504, that's the exception to the presentment and the exception to the dishonor. So you don't fall into a dishonor by asking them to endorse it. They fall into a dishonor because they don't endorse it. And now if they did endorse it, you got the right to ask them to prove up that they are who they are. Because when you go to a bank and you present an instrument for a bank there, they'll tell you, okay, I want to see your identification, and they want to know that whether or not you have the ownership right on that thing that you're trying to cash. And if
well,
you
they're
don't,
not going to endorse.
Call the cops. They're going to call the cops on you for trying to cash a stolen instrument. If you'd force that in court, they'll probably never sign the instrument. You can walk away with the exception rule under 3-504 and not be under dishonor because you made the offer to pay the note right there at the presentment, only if they endorsed it. And when they don't endorse it, then you got that out. And they'll never probably sign that instrument.
No, they won't sign it.
If they did sign it, you could have them arrested because
they won't sign it.
They can't prove that they're the owner.
What about, but Christian, I mean, what about if you walk in there and you already have proof that they're not the owner and you show that?
Well, why aren't you using it?
I am. I just figured out how to.
What's your proof that they're not the owner?
Securities audit.
Oh, bring forth evidence and get it later. Bring it forth as evidence. Discharged. Get the case discharged. Get it kicked out.
Yep.
Christian, I want to throw this in here. It's from a book I'm reading.
Go ahead.
Understanding Equity and Trust. This is way over my head but something about the bona fide purchaser of a legal estate for value without notice. And it's basically saying that there's some kind of a exception where a trustee can sell the property and the beneficiary is left holding the bag, so to speak. Okay? Like this just kind of blows me away because, it seems to go against everything, but it's right here. It kind of goes like this. I'm just going to read from it. It's a bit long. If it's too long, just let me know. This rule states that if a trustee in breach of trust conveys legal estate and trust property to a bona fide purchaser for value without notice of the trust, that the purchaser takes the property free from the beneficiary's interest. The beneficiary has his remedy against the trustee for breach of trust, but if the trustee has no assets, the beneficiary loses everything. At all events, he has no remedy against the purchaser. How then, it is asked, can the beneficiary have a proprietary interest when we know that such interests have to be good against all the world, and the bona fide purchaser rule shows that our equitable interests are not? The answer is simple and crucial to our understanding of the nature of equitable interests. In the first place, it's important to see what good against all the world does not mean. It is, of course, impossible in most contexts for an owner to prove that he could succeed against the whole world, and he makes no attempt to do so. The expression is a compendious way of saying that the owner, when he is, for example, seeking to recover his property from a third party, does not need a base to claim on some prior transaction with that third party or allege that the third party has done him a wrong. The identity of a third party is irrelevant to the case made by the owner, and he will make out the same proof of his ownership whoever the defendant is. The claim is not like one in contract or tort, where the identity of the defendant is essential to the formulation of the claim. Secondly, it is a characteristic of ownership that an owner may not be able to succeed against a particular defendant because his proprietary interest is defeasible and has been so defeated. There are many examples at common law where owners lose their property in this way, escheat or felony forfeiture for treason and wreck being examples. A closer analogy from the common law, in brackets, they're quite a different theoretical basis, lies in the so-called market overt rule. Under this rule, a common law owner of chattels may lose his ownership in them if they are sold in what is known as market overt, a market held in a privileged location at certain designated times. A non-owner can pass title to chattels if they are sold in such a designated market at that particular time in a particular way. No one argues that because of common law titles are thus defeasible, there is no ownership of chattels at common law. Let's see if I can get through this. What is truly odd about the bona fide purchaser rule in equity? Let's go to page and let's see if I can get jurisdictional. Let's see if this is this okay? Is this making sense here?
Yeah.
Okay, so what is truly odd about the bona fide purchaser rule in equity and the market overt rule at common law is that they stand out from the normal policy of law, particularly in respect of land. In general, the common law in the narrow sense protects vested rights. It is in this sense a capitalist system. Owners do not lose ownership by a mercantile transaction to which they have not consented. And the bona fide purchaser from one who only appeared to have the right to sell will have to restore the property to the owner. Nor inside equity itself will transactions defeat vested equitable proprietary interest. The bona fide purchaser of an equitable interest from someone who had no right to transfer it will find he has nothing. I'll just repeat that. The bona fide purchaser of an equitable interest from someone who had no right to transfer it will find he has nothing. Only in the third case of a conflict between the beneficiary under a trust and a transferee of a legal estate from the trustee does security of transactions prevail over security of vested proprietary rights. The Pilcher versus Rollins rule cannot therefore sensibly be explained in terms of fair play, brackets, unless one is prepared to castigate the vested rights. Solution is unfair. And, and indeed, it is as hard to see the moral superiority of one side over the other as it is hard to disprove of a system which comes down clearly and consistently on one side or the other. The only unacceptable position must be the one we inherit, where we sometimes prefer vested rights and at other times transactions, without letting the purchaser of a legal estate know in advance which rule will apply to him. The bona fide purchaser of a legal estate cannot tell in advance, either from the nature of the location or the nature of the subject matter being transferred, whether he is buying from a fraudulent trustee or from someone without a legal title at all who is able to misrepresent himself as legal owner, and thus has no way in advance of knowing whether he will win or lose. The dishonest trustee and the common law crook will look identical to him. The English explanation of this particular rule comes from constitutional law, from the relationship between common law and equity, and was clearly seen by at least one of the judges in Pilcher versus Rollins. It is a matter of jurisdiction, not a matter of policy. And the next header is the jurisdictional basis of the bona fide purchaser rule. And its equity is and always has been an interventionist jurisdiction.
You just said it all right there before, when you started talking about the trust.
Okay.
Read that trust again.
I'm just going to go up to the dishonest trustee and the common law crook will look identical to him.
No, before that.
Okay. What was I looking for? Fraudulent trustee?
No, it wasn't a fraudulent trustee. It was talking about the trust. You just start talking about the trust.
Okay. Let's see. I'm just going to back right up about a third page here. Only in the third case of conflict between a beneficiary under a trust and a transferee of a legal estate from the trustee does security of transactions prevail over security of vested proprietary rights. The only in the third case of a conflict between the beneficiary under a trust and a transferee of a legal estate from the trustee does security of transactions prevail over security of vested proprietary rights.
That's it right there. You're not going to win unless you come at them under trust, because under trust, everything is different. That's what they're kind of saying colorably, really. The third case, they say, was they treated it as a trust. They came at them under trust, and they were talking about the two higher securities. Well, the trust is the security. The security is the pledge. That is the trust.
That's a weird conflict. Beneficiary under a trust and a transferee of legal estate from the trustee. Does security of transactions prevail?
Corpus juris secundum was saying in a roundabout way that when the trustee has done away with the funds, absconded with the funds, he no longer has any assets, you can trace the funds until the point where you can't trace it any longer and they disappear. And if there are no funds left, you can't get a remedy, so to speak, because there's nothing left. But you can, then it says you can convert it into a tort action, it said, and come at them under a tort action at the at-law side and come at them with a claim for damages and whatnot.
Well, that's luring us into debtor-creditor, though.
They didn't mention anything about a breach of trust, though, and attacking them under trust for a breach of trust. So until you make a breach for trust, claim the trust and breach of trust, but you got to hit them under trust.
Okay. So you're saying it's still there, just but
their bona fide purchaser has no protection under a trust. But under debtor-creditor, a bona fide purchaser will cut off all claims because he's the bona fide purchaser. That's the way they want it, without notice.
Oh. This guy's being a little misleading then.
Yes. They're misleading you not down the trust path. They're misleading you down the debtor-creditor path.
Of course, he's some kind of lawyer.
There is no adequate remedy at law, or there is no remedy, period, at law.
So he's showing up. Sorry, Christian. So he's showing up then the debtor-creditor side of this.
Yes, it appears because they only made one mention on that third case that was anything to do with trust, and it was worded in such a way that it doesn't even look like you know.
Well, I'm glad I shared that with you because that was confusing the heck out of me. And that makes sense. It's a bona fide purchase. That's it right off the bat, right? He's putting himself in that.
Under debtor-creditor is cutting off everybody else that he didn't receive a notice. That's why in that 1985 Oklahoma Supreme Court case is that they established the fact that what must be done first is define who is the bona fide purchaser, and he's the real party.
He has to be careful if he's a bona fide purchaser. He wants to get back into trust.
Well, trust cuts him off because it's in a different realm.
Oh, right.
Title, it's got to do with the equitable title. Because the trustee owed the duty to the beneficiary, and that's a breach of performance, breach of trust. And that's enforceable in equity only.
Well, they're beating us up with the left and the rights then. They're using trust to take it from us, and then they throw us back in debtor-creditor.
Right.
Oh, well, that opens my eyes to a new dynamic yet again. Gotta be careful what I read here.
Yeah. Christian? Yeah, make it short, Jacob.
Okay. Well, the thing that we went over tonight, which is withdraw, in order to withdraw and discharge all documents, etc.
Right.
This is a new framework of language for what we've discussed in the past, basically.
Yeah, kind of, because we really haven't discussed any language in the past. Not too much other than maybe short indentures of, I grant you or give you my name and a few other things.
But I mean, this is to order back the note, correct?
Yes.
Okay. Thanks, Christian. Night.
All right, night all.
Good night.